right?
That's on.
The first in time, first in right concept that we talked about in recording in general priorities in life. So the lender, as I talked about when I went through that lovely, fascinating day about loan documents that I actually had people dozing off, the lenders want to be in first position. They want to know that they're in control, and with the exception of real estate taxes, they can really be in control, and they can say, no, no one else can get ahead of us. So if you have tenants in a project and you want to put a mortgage on it, the bank is going to require that something come from the tenants to say, even though we were here first, we're going to be behind the bank in all regards. And that something is called a subordination. It's a document that it can be used in financing as well, and it is used to shift the priorities of time. So a subordination agreement takes whoever's in first position time-wise and moves them down and puts another person ahead of them by contract. So in the body of the lease, there's a provision that recites that the lease is subordinate to any financing that presently or in the future encumbers the property. Now, this has a provision in here that says absolutely that the lease will be subordinate and is subordinate. So the tenant is agreeing to that at the time the lease is entered into, but it also provides, the second part of the clause, that the tenant will execute a document in favor of the lender because the lenders may not be happy with just what's in the lease. From a title standpoint, when I'm issuing title insurance to insure a loan, if this clause is in there the way it's written, where it's automatic, you can rely upon it. You don't have to have the piece of paper to eliminate the exception for the lease in a loan policy, but the banks typically require it. Now, if you have a strong enough tenant, the tenant's going to ask for something in return. The tenant is going to ask for the bank to say, if there is a foreclosure, but I, the tenant, am still doing what I'm supposed to do, I'm paying the rent, I'm living up to my obligations, that I'm not going to be thrown out, I'm not going to be evicted, or the technical term is I'm not going to be disturbed. So the agreement is called a subordination and non-disturbance agreement. There's one more component to the agreement, although slightly less important, and that's attornment. A-T-T-O-R-N-M-E-N-T. I'm not going to get you on that. It's for your, trust me, I'm not trying to be too technical, but the typical agreement is SNDA, Subordination, Non-Disturbance, and Attornment Agreement. The attornment says that if a foreclosure occurs, that the tenant will then look to the bank or whoever succeeds the interest of the landlord as the new landlord and live up to the lease. Funny side story, for a short time, I had a legal assistant who was not real estate trained. She was an absolute amazing secretary, great typist, great skills, but she had worked in litigation for many years. And just in the course of rotating people, I needed somebody, and she volunteered to help. And I must have dictated some letter enclosing a subordination, non-disturbance, and attornment agreement. Well, she didn't know the term, because didn't quite hear exactly how I said it, and the letter came back that we were sending an insubordination and torment agreement. Assignment and subletting. This is how the landlord controls who he's doing business with. And I don't know if I touched on this a little bit in one of the earlier classes, but I'm going to touch on it briefly now, and then I'm going to talk a little bit more about it when I talk about what Mr. Helmholtz was talking about in the low points in the cycle, and how these kinds of things can be used to protect in the low points of the cycle. But this basically, the assignment provision prohibits, if there was nothing in the lease, if it was completely silent, the tenant would have the right to transfer the lease. Now, a transfer, just like that, an assignment from one tenant to another tenant, transfers the lease, but it does not release the party who signed the lease to begin with, unless there was a written express agreement by the landlord that released them. So an assignment transfers the lease. A landlord wants to know, because he's credit qualified or business qualified, his tenant. So most leases, almost all leases, are going to say that the tenant cannot assign without the prior written consent of the landlord. The problem leases, and where you get into an issue, is if that sentence is the end of the sentence, where it says the tenant cannot assign the lease without the prior written consent of the landlord. That's a problem, because there's no standard of consent. So there happens to be case law in Florida, going back, I don't know how many years, but it is still good law, that says that a landlord has to be commercially reasonable in consenting or not consenting to an assignment. And there are standards of commercial reasonableness, including the creditworthiness of the tenant, whether the tenant has adequate business experience to operate in the premises, and a few other things like that. However, the typical standard that you will see with a normal landlord, except perhaps for one who operates in Boca that you might be familiar with, is what's up there that says that the landlord's consent will not be unreasonably withheld. That's a little bit of a nebulous standard, but it kind of says so that the landlord does have to be commercially reasonable. Sometimes more finesse, unreasonably withheld or delayed. As you may have gathered, and maybe I've even admitted this to you, this is basically a landlord's form of lease, because that's who hires you to write a lease. I do both sides of the transaction, so I know how to alter the leases, and there's all kinds of little things you can do. That's pretty reasonable. The next sentence, though, gives the landlord a little more leeway to make conditions. It talks about basically the financial strength of the tenant or the tenant's guarantor. Then, even though the law says this, just to make sure that nobody's confused, it says we're not releasing anybody. It says that consent to assignment is not a release. And finally, and I think I did touch on this when we were talking about uses and other things last week, I have a provision in here that says that a transfer of the ownership interest in the tenant, I think this says 25% or more, is deemed to be an assignment. So if all the lease says you can't assign the lease, and your tenant is an LLC or a corporation, you could transfer, absent this provision, you could transfer the stock of the tenant to a buyer or to somebody else, and the lease has not technically been assigned, so you don't have an assignment. So that's what that's for. The other transfer is usually of less than all the lease is called a sublease. I'm sure many of you have encountered a sublease. A sublease can either be for a portion of the premises or for the entire premises for a portion of the term of the lease. Theoretically, the sublease should have a reversion back to the main tenant so that at some point at the end of the lease comes back to the original tenant. As a practical matter, that doesn't really happen. If you're subleasing it, it's just a contract between the tenant and the new person, not involving the landlord, and it usually will run to the end of the term because the tenant wants out for one reason or another. Most leases will require a consent to that. Some there'll be a little finesse here. In this situation, I have a provision in here because if it's a good market and the building itself is well leased, you don't want the tenant to be able to sublease at a profit and deprive the landlord of being able to bring in another tenant at a higher rent. So I put a provision in here that you see again, it's a landlord's form, that says if the tenant gets more than the rent that the tenant is obligated to pay to the landlord, it's got to be turned over to the landlord. So, and I think I have language that specifically says, because we don't want you competing. Yes, it does say that. That's a negotiable provision as well. Very often we'll agree on a 50-50 type of split. So that's assignment and subletting, generally speaking. I'm not getting into indemnification. I'm not going to get into construction. I want to talk about condemnation a little bit, primarily because Carlos mentioned something there, and this is an interesting topic. Because you heard his example where he had to give up a sliver of his property and got back almost all of his money. So the Constitution, I believe it's the United States Constitution, says there can be no taking of private property without just compensation. Okay? The government can't come and take your property away from you unless they pay you for it. Because there are situations where the government needs your property for something, for a public purpose. And that is the magic to condemnation, a public purpose. So they would usually, it would be to expand a roadway. Maybe in some parts of the country, they might decide they want to dam up a river, and they would take the land around the area where it's going to flood. Could be all kinds of reasons like that. Question?
How's that different from eminent domain?
Same thing, same word. Eminent domain is just fancier. It's eminent domain is the legal action, condemnation that's being condemned by the government. They are synonyms. So thank you. Good catch there, though. So in the landlord-tenant setting, you have two estates that we're talking about, if you remember. You have the fee simple estate, the landlord's ownership of the land, and you have the tenant's ownership for a term of years. Absent any other language, when you went to do a condemnation action, there should be an apportionment of the payment from the government between the two estates, because the government is taking all. They're taking a piece of both estates, and absent language that says to the contrary, it would have to be apportioned based upon how many years the tenant has possession and what it's taking away from the landlord. But if you think about it, the landlord is actually being deprived of his property and his ability to produce income from that property. And so we don't give the tenant any portion of the value of the leasehold, because the tenant no longer has to pay rent on that leasehold, and the landlord is being deprived of the rent. So by contract, we say, in the event it's taken, the tenant gets no part of the condemnation proceeds for the taking of the property, but the tenant will have the right to make a separate claim against the condemning authority for the expenses, business damages. Maybe he has lesser premises, and so he can't do the same amount of business. Maybe he has to move and relocate his business, and he's going to have all kinds of expenses associated with that. So the tenant's allowed to do that. Typically, if it's less than the total amount of the property being taken, there's a provision that says the rent is going to be proportionally reduced. As a practical matter, it would be very, very rare that a government taking would take a piece of building and take a piece of premises. What's more likely to happen, and what's much more likely and necessary to protect against, is parking. They're going to take land. You can expand a road, you're going to chop off a piece of the front of the land. That's where the parking usually is, especially in a retail setting. It could adversely affect the tenant's business, or worse, reduce the amount of parking to below what's required by law for the size of the building. That's what you have to protect against. And from a tenant's standpoint, I always add in something that says, when they talk about a portion of the premises, I'll put in or material portion of the parking serving the premises, or maybe a little more defined and say, which brings it below the minimum required by law. So, a little bit on the condemnation. There are tax benefits to the condemnation. We talked about tax-deferred exchanges under 1031, and there is another provision. Don't hold me to this. I think it's 1033. Not important. It's a tax code number, but it deals with a government taking of your property. It's more liberal. You have 2 years to replace it, and you don't have to escrow the money. But the government said, the tax code says that if your property is taken, your real property is taken by eminent domain, and you reinvest it within 2 years, you don't have to pay the tax on the gain. It gets deferred, just like a 1031. Little tax quirk there. Destruction of the premises, well, bad things happen. Down here, the bad thing is usually a hurricane. And what happens is the property can get damaged, partially, totally, enough that it cannot be occupied. In that case, what should happen is the rent should abate. The landlord should fix what the landlord is obligated to fix. There's insurance money, as long as the insurance money isn't taken by the bank, which can happen in some lending situations. And during the time that the property cannot be used, the rent should be abated. When the property is usable again, the rent starts back up. If it's so bad, and usually I think the standard we use is 50% or more, it's all negotiable. If it's so bad, the landlord wants to retain the right to cancel, because if it's really that much of a portion of the property, maybe the landlord wants to do something else with the property. Now, because when you have to rebuild more than 50%, there's all kinds of zoning and building code requirements that come into account. Maybe the landlord says, I don't want to have retail here anymore. This is now an office site or an apartment site. Cancels the lease, everybody goes away, everybody gets their insurance proceeds, and the lease terminates, just like it was the end of the lease. Less likely than a partial. Partial might be one suite. We had when our offices were at Cypress Creek, there was one set of offices that had a door onto the 5th floor roof. The door blew out. That attorney's office was completely wiped out. That's a partial damage. So theoretically, you would get an abatement for a small percentage of it because you can't use it. The finesse that goes on, if you look at remember, in South Florida, there's a few different issues that we don't account for in other markets. Number one, if we have a hurricane, everything really goes out of whack. So you see the language I have in here where it talks about the nature of a casualty is one of widespread geographic proportion. So if you have a hurricane that affects, let's say, the Tri-County area, you're not going to be able to get insurance adjusters to come out. You're not going to be able to get roofers to come out. You're not going to be able to get any tradespeople to come out and repair the premises for an extended period of time. So what might be reasonable, if it was just a car ran into the building, or, which I had that happen actually.
That's so reasonable.
What's that?
It's so reasonable just having a car run into the
So anybody that knows East Fort Lauderdale, they decided along 13th Street, north of the downtown, that, gee, what a lovely street, we're going to fix the traffic pattern, and we're going to put in a couple of roundabouts. Okay? Roundabouts are very common in Europe. Roundabouts are not very common here. Well, somebody who knows under what condition came around the roundabout way too fast, didn't quite make it, and boom, into my client's building. So, you know, I had to, the worst part was...
The carpet store?
Yeah. Actually,
Which
yes.
one?
Tile and carpet or something like that?
It was called Paul's.
Yeah.
Yeah. So good. See, I love this. I love that everybody knows the sites I'm talking about. So we had to, we actually were in the middle of a transaction. I had to say, listen, we have to wait because we have a car hole and it has to be fixed. So that's a problem. And it really was literally a hole in the side of the building that had to be fixed. It got fixed. It got done. So that's an unusual kind of damage, but that doesn't keep the tenant from operating. You know, there's just that was mostly cosmetic, except maybe in one small part. When a hurricane comes through and wipes everything out, you really need to make sure that everybody's got more time to react and to do what needs to be done. The other problem is, and this is something that I've always had trouble negotiating with people that are not from South Florida, because you know you get lenders on big transactions, and the lenders are based in other cities. If the power goes out in here, and I'm operating an office, I got two problems. Number one, I can't operate my office machinery. And number two, I can't breathe. You can't open a window. I'm sure these windows don't open. No office windows open anymore. Once upon a time, you went crank, 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 and you opened the window, the breeze went through, and it was fine. You could suffer a little bit, but you could work. You just lit the candle. But it doesn't work like that anymore. So even though the building is fine, and everything is wonderful, and the landlord doesn't understand why you're complaining, especially the landlords in Manhattan, if you're stuck and you can't function, that should be a reason for the rent to abate, and that should be defined in the damage and destruction provision, if you're representing a tenant.
Is that covered by insurance to the landlord?
That's a very good question. Without going to the text exactly. That's a very good question. The question was, is something like that covered by insurance? Well, there's two kinds of insurance.
Great question.
Any question that lets me talk about something else.
Like insurance, my long liability.
You like insurance?
Well, I just have a lot of experience with the terms.
Anybody that likes insurance needs mental health.
I like what it did for me.
Not surprising.
You think loan documents are boring? Okay, actually, the only good thing about the insurance is when we're negotiating something and you have a position you're trying to support, there's a couple of excuses that you can come up with, and one of which is the insurance policy requires it. And you know, people just say, oh, okay, and they'll give into that. Or my lender requires it. Oh, okay, and they'll give into that as well, if you use it strategically. So, there's two types of insurance that will come into account. Let's say the power goes out for 10 days. And I had this situation, again, when Hurricane Wilma came through, our office at Cypress Creek, we didn't know it, but the generator didn't work in the building. So we had no electricity. It caused a much more serious problem because back then, not knowing any better, our law firm's servers were located in that office. And you should have heard the managing partner in the Orlando office screaming because nothing happened in Orlando, it was fine, they couldn't function because our servers didn't work. And the building was supposed to have a generator, the generator didn't work.
No redundancy?
Not back then, this is 2005. Now, obviously, we've learned a lesson, not we, but everybody's changed the way they do things.
Liability on this one.
So, so we're talking, so there's two kinds of insurance you can have. From the tenant's side, the tenant maintains something called business interruption insurance. And with business interruption insurance, you have a policy that says, if because of some catastrophe or insured loss, you cannot operate your business, you get paid up to whatever your coverage is, $35,000 a day, whatever the number might be. The problem with that is, most of the time with that coverage, you have to show loss of revenue, which means you're going to have to prove to the insurance company, based upon historical earnings, what you would have earned for that 10 days to justify your claim. And some businesses can do it, some businesses can't. Things are cyclical. Money does not come in evenly over the year in any business. It's just the nature of business. So it's a little difficult. The flip side, on the landlord's side, is called loss of rents insurance. Loss of rent insurance simply says, this is real tough, that if there is a provision in the lease by which the tenant is entitled to abate the rent and not pay the rent, the landlord can claim loss of rent insurance. So for the same 10 days, all you do is look at the lease and say, what's 10 days worth of rent? It's much easier to compute. From a financial allocation, we talked about, if you remember, the gross lease, the net lease, who pays what? If you lump that loss of rents insurance into the property expenses so that the cost gets paid by the tenant, then it doesn't matter who's carrying the insurance. You go with whatever insurance is easier to make the claim on. The landlord and tenant agree. The tenant's going to pay for it. The landlord's going to carry it. And it's much easier. And then the tenant doesn't pay any rent, and there's less arguments. Doesn't always work, but it's a real easy thing to do. So that's what happens with destruction.
Do lenders require that sometimes? Is that?
Yes. Oh, absolutely.
Because that's, I mean, you got. I'm just thinking up the ladder. They don't have to pay it. Someone does.
Somebody does, and lenders will sometimes ask for as much as 12 months coverage.
Wow.
Well, you know, you never know what's going to. It takes a long time. What's that?
And then there's the whole background of the area.
The area, right. I don't want to talk about defaults or remedies right now. I'm just really using this as examples without getting overly technical because I have some optional things to talk about. Hazardous materials is a covenant. Hazardous materials, do we have it? There's a definition, but I mean, it basically means materials that are hazardous. It's your typical things. Sorry. I mean, that's how definitions unfortunately work. There are government definitions of what it is. If you think about it, hazardous materials, oil, gas, you know, if you're talking about gas station type of thing, manufacturing chemicals, corrosives, almost anything. And as you're going to see, if you stay awake and stay in class through to later on, when we get into everybody's anticipated favorite subject, cannabis leases, you'll find that there's things like fertilizer and other chemicals that can be used in the agricultural process that are also hazardous that you have to watch out for. That's a preview. And of course there's the miscellaneous, then that's always important. Oh, there is one little thing here. Recording. This is obviously again, I'm going to admit to it being a landlord's type of lease. in certain types of leases, and certain types of lease provisions, the parties are going to want to record a memorandum in the public records to provide notice to either to the general public or to a potential buyer or to a potential lender of the rights of the parties. The landlord doesn't really want this in a short-term lease because when the tenant leaves, when the lease ends, and you don't get the tenant to sign off removing this document, this becomes a cloud on the title of the landlord's property, and it's going to have to be explained away. It can be dealt with, but you're going to have to deal with it in the future. On a long-term lease, especially a lease that's got long options and things that I'm about to get into, the tenant's going to insist on some kind of a memorandum to protect the tenant's rights against future buyers of the property and things of that nature. The one exception to this that I didn't go back to is there's a restriction in the lease and something the landlord wants against construction liens. If you are building something and you certainly don't want the tenant who's building the interior partitions and doing whatever he's doing to get his premises ready, you don't want him to be able to create a lien if he doesn't pay his contractor on the landlord's property. We have two separate property interests. The landlord wants his title kept pristine. There is a provision that when we have in the lease, if anybody's looked at the lease document, it quite simply says restriction against construction liens, but there is a provision in the Florida statutes that lets the landlord record a document that says that all our leases have this or similar provision. There it is. This or a similar provision in the lease, and anybody doing business with the tenant is put on notice that you as a contractor are not going to have the right to encumber the landlord's interest with a tenant's obligation. Very important to protect the landlord's title. It even says that the landlord shall have the right to record a notice. So that you're giving the landlord the right to record a generic notice, but you really don't want specific rights of the tenant recorded to cloud up the public records. Questions? Okay, let's move into the optional portion of this. Optional, what does he mean by that? I'm going to talk about options. All kinds of options. Yes, that's the first thing on my outline, actually. Options to renew. I want to see if I can, bear with me 1 second while I fumble through this system, which I'm doing much better on. I thought. I'll get there. I promise. I lied. There's tech support when I need you.
I need options 101 before I can do this.
What's that?
I need like options 101 before we dive into options laws. I need to know.
We know what an option is?
Generally,
It's
no.
optional.
What's an option? Option choice? A legal choice? I don't know.
Hold on. It's a right.
See? Way out.
I profusely apologize for my inability to get where I want to get. All right, screw it. We're going to talk about it now. Okay, so options. It's funny because the first thing I mentioned about options is the one-sided. What is an option? It's a good question, right?
Right, I asked you.
An option is a contractual right that one party gives to the other, where the recipient has the unilateral right to make a decision to exercise or not exercise the contractual right. Sound kind of fancy, but what am I talking about?
Yeah, layman's terms.
Layman's terms. We have a lease for 10 years, okay? You're the tenant. I'm going to be the landlord in this example. And so at the end of the 10 years, you have the right to extend the lease. You alone have the right to make the decision and bind me. I'm giving you the right up front. I'm giving you the right to exercise a right, an option. An option because it's your choice to extend the lease or not extend the lease. You don't have to, the not extend, depending on how fancy somebody wants to get, you don't really need to say, no, I'm not going to. It would be a nice courteous thing after 10 years to say to your landlord, listen, I'm moving on. But not everybody does that. There are some provisions, if you're nasty enough, see who we were talking about before, to have a provision that if you don't tell your landlord that you're going to leave, and this you'll see this in shorter term leases as well, they'll penalize you because you're not giving them an opportunity to go out and find a new tenant. So the option to renew, like I said, is one-sided. It is up to the tenant to exercise it. Typically, in the option to renew, we would have a provision to say that if the tenant is in default under the lease, that the tenant does not have the right to exercise the option. And the reason for that is, if the tenant has been bad, I mean, let's face it, if this is a contract between the two parties, if the tenant hasn't lived up to its obligations under the contract, then it shouldn't be in a position to exercise its rights to make the landlord live up to its part of the contract. A little bit of finesse, and if I could find the email, I would show you, and I'm going to make another effort at it in a second. A little bit of finesse, I have a provision in there, in addition to, you can't be in default at the time the option is exercisable. I'll tell you when that is and how, we'll talk about that in a minute. And you can't be in default at the time the option term begins. So let's say it's exercisable in a long-term lease 180 days or 6 months prior to the end of the term. You can't be in default then. And when that term is about to start, you can't be in default because you don't want to give a defaulting tenant the right to continue. Finesse. I have a provision that says if the tenant is in default, monetary default means they haven't paid their rent more than twice in a calendar year during the term of the lease, then the option goes away. Because if you have, and that's negotiable, depending on the length of the term, depending upon the strength of the parties. Somebody might say 3 times a year. Somebody might say 5 times during 10 years. All kinds of different ways to do it. But the concept is, if the tenant is a chronic non-payer, you don't want him to have the right to stay in your space and bind you. So that's important. How do you exercise it? Well, written notice. The tenant has to give the landlord written notice of their intention to exercise, excuse me, I slipped on something. The tenant has to give the landlord written notice of the exercise of the option. And I'll tell you why I stopped myself. Cases have been lost on a letter from the tenant that says, I intend to exercise my option. Okay? I intend to touch that black thing on the desk here. I'm not touching it. I'm not touching you. But I intend to touch it. That doesn't mean I've touched it. To quote a very famous little green guy, do or don't do, there is no try. Anybody?
So the phrasing would be choosing to exercise.
I exercise. I hereby elect to exercise my option. I hereby exercise my option. I exercise my option. I don't like H words. You don't need H words. You don't need a hereby, hereinafter, here and above. You don't need H words in drafting a legal document.
That's all I learned about
People use it. Now there are times when it's going to get a little bit wordier to direct you, as defined elsewhere in the document, as opposed to hereinafter defined. But H words are they're unnecessary most of the time. Some tenants, so time for exercise. Typically, the time for exercise of an option is going to depend upon the length of the lease. If you have a short-term lease, a 3-year lease, it's probably not fair to ask for 180 days because it's such a large percentage of the time of the lease. So maybe you'll drop down to 90. You need to give the landlord enough time so that if you don't exercise, the landlord can start looking for another tenant. So the time for exercise is typically, it's usually 180, it's 90 to 180. It's all negotiable, but those are typical parameters. I'm I'm drinking water, I'm hearing water. Some tenants who have enough bargaining strength will negotiate a clause that says, if the landlord doesn't receive that notice within 20 days after that 180-day date, that the landlord is obligated to send the tenant a reminder, because the tenant doesn't want to lose its rights, especially if it's a prime location, they've invested a lot of money, there's all kinds of things like that. There's also a situation I call oops, where the tenant comes running and says, without the, oh my God, I forgot. I knew I was supposed to do this, I completely forgot. Landlord, I'm so sorry, I know I'm a month late, I want to exercise my option. Now you're in the wah-ha-ha-ha clause zone, because the landlord can actually say, well, you blew it, let's negotiate a higher rent. So, and that happens. There also are court cases where the tenant comes forward and says, look, we had a 180-day provision, I missed it by 15 days. As soon as I realized I missed it, I came running forward. Nothing happened bad to the landlord by my missing the 15 days. However, Judge, I have $3 million invested because I built a building on this site. My business is dependent upon this location. I've been in here for 10 years and established, and my option is for another 10 years. My financing, all kinds of factors. And the courts in those kinds of situations where there's excusable neglect, or they see all these extenuating factors, or to prevent a forfeiture, because the law does not like forfeiture. That's one of those bad words of the law. The courts will turn around and say, okay, we're going to let the tenant exercise the option because the default was minor and the consequences are huge. So the courts have the powers to do such things. Now, I will say, you remember when we were talking about the contract, I pointed out a provision, time is of the essence. And time is of the essence basically boils down to, I really, really mean it. So if I say 180 days, I really, really mean 180 days. Not 170 days, not 175 days. Time is of the essence. If that language is in there, and that tenant's on notice, it's most likely the court is not going to forgive a 20, 30-day mistake. Okay. Terms of the option to renew. There was a recent court case, again, very recent actually, where all it said was the tenant will have a right to renew the lease at a fair market value rent. And the courts held that it was so vague and non-specific that a contract couldn't be formed by that, and they couldn't bind the landlord if the parties couldn't agree on the rent. And so the court threw the option out altogether. So, one of the most important things from a tenant's perspective is how to determine what the rent's going to be for the option. Sometimes, rarely, it's a fixed number. And the reason I say rarely is because you don't really know in the future what's going to happen to the rental market. Go back to the ups and downs charts over there. If the market is way up and the rent market is way up, the landlord's going to be hurt by a lower rent, fixed rent with no adjustments. The tenant is never hurt. Why? Because it's an option. So if let's say the rent is 20% above the market, the tenant comes to the landlord and says, listen, I know I have this option to renew, but the rent's too high. If you want to keep me, lower the rent. Now, they'll reach an agreement in the middle in most cases, because if the market is down, the landlord knows he's going to have a hard time replacing that tenant at a good rate. Another simple way to do it, that's probably relatively common, is if you have a lease that the rent increases annually by 3% during the term of the lease, it's very easy. You just say if they exercise the option, it keeps increasing by 3%. Because remember, if you do your math, those increases are cumulative. So you start off at $10 a square foot, it's going to be 3% above that, and then it's going to be 3% of the year 2, and then 3% of year 3, and so it's going to be a cumulative increase, theoretically, to keep up with the cost of living, but in reality, you're increasing it based upon the increased rent, so it's growing. And like the arrow on the board, as the rent grows steadily, the value of the property grows because you're selling an income stream. We used to see a lot of consumer price index clauses in options, and in leases as well, that says the rent will be increased by increases in the consumer price index. The consumer price index doesn't go down. Maybe at some time in history it might have gone down, but not in my lifetime. Right now it's very low. It's probably 2, 2.25. I don't know if you've had occasion to study it in your finance courses, but the consumer price index is published by the government. It's based upon all kinds of factors all around the country and what people are paying for goods and services and such. It's low right now. I have seen it where it's been at 12%. So in the days when it was at 12%, you would negotiate caps. So it would be the consumer price index, but not to exceed 6 or 8%, because it would kill the tenant for the rent to go up quite that high. Conversely, you'll get a landlord saying, oh, put a floor in there. Consumer price index not to exceed 8 for the tenant, not to be less than 4 for the landlord. Those kinds of revisions are common with the CPI. So you use that to determine the rent for the renewal. There could be a formula. The formula could be something like, well, you could use a CPI look-back formula where you've had, say, let's say you've had the rent going up at 3% a year. And the landlord is worried, because it's a 10-year lease, for example, that the costs of the rental market have been so dramatically different from when the lease started to now that the landlord has a look-back provision that says, for the first year of the renewal option, we're going to compare the CPI back 10 years ago to the CPI today, and then we're going to add the 3% in the future years. That's a formula. You could say that the rents are going to be the average of the similar square footage offices or stores within the landlord's project entered into in the last 12 months per square foot rent. So you get statistics that way. You could say, similar rents in the area. You'd have to get broker information or something to indicate what the rents were for similar properties in the area. More significant leases will actually provide for an appraisal. It'll be an appraisal of, again, similar properties. You'll get a formal MAI appraisal, which costs money. And if the tenant doesn't agree with the landlord's appraisal, the tenant would have the right to get its own appraisal. And if the two appraisers don't agree, you can go one of two ways. You can hire a third appraiser, split the cost, or you can average the two of them. So it's endless. But if it says just market rent, it's vague, and the tenant has no option. Other things to consider in the exercise of an option to renew are, do you have to pay the brokerage commission again? Real estate agents in the room will understand that if you've worked hard to get a tenant in there and you get a commission, the commission is computed based upon the rent for the initial term of the lease. If the tenant re-ups, really, the landlord's position is that the broker hasn't done anything to cause that renewal. They got paid a chunk of change, and they shouldn't get paid again. It's all negotiable. It's part of the listing, it's part of what's in the lease, that's between the landlord and the broker. But sometimes there's a provision for it, and sometimes there isn't. The other thing that there may or may not be a provision for, usually not, at the beginning of the lease, the landlord contributes money to improve the space, to build it out. Not at the renewal, unless there's a specific, I've seen situations where it says, if the tenant, again, longer term leases, if at the end of 10 years, the tenant exercises the option to renew the office lease, the landlord agrees to paint and recarpet, or to provide an allowance for paint and recarpet. And honestly, from a landlord's perspective, it makes sense, because if they're going to bring a new tenant in, it's going to cost them a lot more than that. They are certainly going to have to pay leasing commissions for a new tenant, and they're probably going to have to do much more improvements than just paint and carpet, because typically a new tenant coming in is going to want a configuration change, which involves construction. And free rent. It's all economics. Okay, That's the option to renew. I would like to ask for a moment to see if I can find some of these other provisions so that I just don't keep rattling, because there are other kinds of options that are important. So give me a half a second.
Half a second, Grant.
We'll allow it.
Bless you. Because some of these options play into the concepts of what to do when things go bad. Aha. So this is what an option to renew looks like. And here you'll see in B1 where it talks about no default, renewal terms are the same except for the rent, and then how it's exercised. My other options. No, that's not where I want to be. All right, forget it, it's not here. Sorry. All right, different kinds of options and important types of options. Again, the exercise of the different options is going to be pretty much the same. Notice provisions and things like that. Let me talk about the option to expand. Usually you'll find this in either a retail setting or in an office setting. I was talking a little while ago with Ryan about a local restaurant from whence I got my lunch today, and Las Patas, that you may all know and love. Years ago, Las Patas just had the north half of what you see there today, which was basically the service at the counter where the food is actually prepared, and an aisle to stand in and crowd and yell at what you want and watch them do the stuff. And there really wasn't any place to eat. There may have been stools or something against the wall. Well, when the opportunity arose, they wanted to take the store bay to the south of them that somebody vacated, and they were able to do that and put seating in. So you can actually go and sit down and eat there. They actually doubled the size. And that just happened because it was available. In certain types of lease settings where the tenant is thinking that they're probably going to expand in the future, the tenant asks the landlord for an option to expand usually to the adjacent premises. Adjacent means next to, or in Arkansas, right up close. The tenant wants that right. Well, what triggers it? It's not the same as an option to renew, where the trigger is a date, 180 days prior to the end of the term. The trigger could be when the adjacent premises becomes available, or when the landlord is about to lease it to somebody else, which is really more of a right of first refusal. But so that again, it's all a negotiation as to when the tenant would have to make a decision. So if the situation where it's just available, that would be called a right of first offer, as opposed to a right of first refusal. A right of first offer says, before the landlord offers it to anybody else, any stranger, anybody else coming in that wants to lease space, the landlord has to first contact the tenant and say, I'm going to put this on the market. I'm offering it to you. Now, the terms become a negotiation when the option is negotiated. So, it's either when the offer is made at the terms that the landlord could rent it out to a third party based upon what the landlord believes, aka market, and it's really thoroughly the landlord's decision, or it could be that if it's available, the tenant has the right to add it to its lease on the same terms and conditions as the main premises are on. That would be a little less likely from a landlord standpoint, but on the other hand, if the lease is escalating at 3% a year or some other escalation that would happen to the rent, it could be okay because you're looking at a per square foot basis. So the option to expand gives the tenant the right to take more space when it's available or when the landlord gets an offer. Now, when the landlord gets an offer for the space, the landlord is sitting there with empty space, I come along and I want to lease the space next to you. This could trigger the right of first refusal. Now the question becomes, in a real right of first refusal of any nature, the person that holds the right, which would be the tenant in this case, has to match the third party offer. So the terms are dictated by the third party offer. Or, should the terms be what were originally negotiated for the main space, so that the landlord just adds the additional space to the main lease on the same terms and conditions. In a true right of first refusal, you'd match the other tenant's offer. So that's expansion and rights of first refusal to lease. Sometimes, more particularly with a single purpose building, the tenant wants the right to buy the place. It could be, it's usually with a smaller premises, but not necessarily. The corporate headquarters that Ramos was talking about earlier, where they had their corporate business, sometimes they don't own it. The tenant is in there, the tenant is operating, the landlord owns it, and now the tenant is doing better and the tenant wants to buy it. So the tenant will negotiate at the beginning of the lease an option to purchase the building. All the terms will be defined, just like the option to renew. You have to have a date of exercise. When does it expire? It's more sensitive as to how you compute the price, though, because you can have a fixed price option, which is usually only for a year or two because the market fluctuates. You could have a fixed price option with a formulaic increase, so that the price increases X% per year, like the rent. It could increase with the CPI. It could increase by appraisal. Then you're really not having so much of an option, because if it's an appraisal, the price is up in the air and it could be almost anything. So in that case, the landlord could almost dictate the price. So the option to purchase is relatively simple in terms of its mechanics. It's complicated in figuring out the terms of the price. And of course, if the tenant exercises the option to purchase and purchases the property, regardless of what the lease says about repair obligations and other maintenance obligations, the tenant is now becoming the owner, and everything, the landlord shouldn't have to do anything at that closing to ready the property or do anything to the property. It's simply a conveyance, to obviously title, dock steps, all the usual things, but other than that, nothing. Take it as is. Also, there's the little fine tune, and that is that, number one, the lease stays in effect until the closing under the option to purchase, because you don't want a limbo there where they exercise the option, all of a sudden the lease goes away. And number two, the lease does go away when the tenant acquires it. So the contractual obligations between the parties end at the closing. Similar to an option to purchase, but more governed by third-party actions, is a right of first refusal. And this is something you'll see much more frequently in a landlord-tenant situation, because the landlord doesn't want to be too heavily burdened. It's too difficult to get them to agree to fix the price, even with a formula in most cases. But if a third party comes along and says, I will pay you $10 million for this building, and the landlord says, yes, that's a good price. A right of first refusal says that the tenant will have the right to match the terms and conditions of the third party. So of an offer that is acceptable to the landlord. That means the tenant can't send his brother-in-law to offer $3 million for a $10 million building and trigger the right. It has to be an offer from a third party that is acceptable to the landlord in order for it to trigger this right of first refusal. And then all the terms and conditions should be in whatever's in that contract. Yes?
So going on that same vein of like having someone come in and give you an offer and say, oh hey, I got an offer from this guy, are you willing to, you know, take it? How can they verify that? Like what happens if you offer to, or you try to make payment and like you can't make it at as high as an offer as like he said he got from a third party, and then you leave and then he does not execute that deal? Like,
That's his problem.
But I'm saying, like, could you take him to court? Because he did not let you pay it because he had some outrageous offer that didn't even get exercised, so it was from a friend of his that never intended to buy it in the first place. But you left and did not get the property.
Well, you wouldn't, you don't necessarily leave. The fact that if you have a valid lease and the landlord sells the building, that does not terminate your lease.
Gotcha.
Okay? However, if it's an outrageous, so finesse, it's a good question because it does lead to a finesse part of it. And that is, if the deal changes, materially changes, so in your example, the third party comes along with a $10 million number. And now we get down towards closing, and the guy says, I don't think it's worth 10, I think it's only worth 7, or I can't pay for 90 days, or I can't pay for 120 days, or something like that. If it's drafted correctly, if the option is drafted correctly, the landlord should be able to go back should be required to go back to the tenant and re-offer it at the reduced number.
Gotcha.
That's a little bit of protection. Not a lot, but a little bit. But it does not, the sale of the building by the landlord does not terminate the lease. There are clauses in the lease that you can put into a lease to protect the landlord. I was just working on one of these yesterday. You have a property that's in a redevelopment zone. When I say zone, I mean something that the landlord is considering redeveloping. It's an old dilapidated building. He's got a tenant in there doing whatever he's doing, and he's entered into a lease, but the landlord wants to protect in case some rich developer comes along and wants to offer lots and lots of money because they want to buy the whole block and redevelop it. You can negotiate a provision. Again, it's got to be agreed to, but you can negotiate a provision that says if the landlord elects to demolish the building or sell it for redevelopment, the landlord can terminate the lease on 120, 180, 90 days, whatever number of days you negotiate notice, and maybe compensate the tenant. Usually the compensation will be free rent for the rest of that 120 days while the tenant relocates. And it's something that the tenant agrees to when the lease is signed, so it's not a surprise.
What's that provision called?
Landlord's right to terminate.
Okay.
Real easy. Nothing magical. In some circumstances, the tenant might need a right to terminate, which I'm going to get into in just a minute when we go into yet another topic. But so that can work either way. The tenant, for example, I think we were talking about this, we touched on this briefly. Government leases have a provision. I just was working on one with the city, where it says if the agency that's occupying the premises is not funded for the coming year, then the city has the right to terminate the lease. Or, in some leases it'll say, if the city or state has a government-owned building that becomes available within say a 5-mile radius, the city has the right to terminate the lease to move the agency to the government-owned building and stop paying rent. I know we were talking about some more egregious tenant-oriented termination provisions, but for the most part, it's those kinds of things. If the tenant's business suddenly became illegal, which is a good segue into something else. What?
Pill clinics. The pill mills from down on Commercial, there's like 7 or 8 of them.
I don't know about that because
How you know?
because what you're calling a pill mill is technically a pharmacy.
And doctor's office. There's a one-stop
It's
shop.
but the use itself isn't necessarily being prohibited. The use is being abused by practice. There's a difference. It's one thing to say, to pass a law that says you cannot have pharmacies anywhere in the city of Fort Lauderdale after January 1st, 2020. So all the pharmacies in the city of Fort Lauderdale have to close. Never happened, it's kind of a wild example. So in that situation, yes, you can get rid of all the pill mills.
So it's literally the specific business, not.
It's how they're operating the pharmacy. That they are operating the pharmacy in conjunction / cahoots with disreputable physicians who are over-prescribing or prescribing to the wrong people. So the pharmacy is not doing anything wrong. The pharmacy is dispensing according to a prescription. It's the issuance of the prescription that's actually the wrong activity. So it's not the use, it's the abuse of the practice.
Okay.
Okay?
So that wouldn't count as illegal activity in the building?
The activity is not illegal.
It's not.
The activity in the building that's being performed by the tenant is the dispensing of pharmaceuticals pursuant to a prescription from a licensed physician. Right?
Right.
Okay. That's what's going on. The physician may be doing something wrong.
In the facility.
That doesn't matter. That could be a default under the physician's lease. Because you remember, I think, we saw, I don't know if I went over it, but there's a provision in most every lease that obligates the tenant to comply with laws.
If the tenant, the pharmacy we're talking about, was working with a particular doctor to facilitate the dispensary of this, whatever it is,
Pills.
pills at a rate that's probably above and beyond what should be happening, that's a conspiracy, isn't it? Even though what he's doing is dispensing according to the doctor's orders, if it's part of a cabal, is that a conspiracy? Is it part of a conspiracy?
That's a tough one. I mean, it's tough to carry that all the way to a landlord-tenant default. You'd have to, I mean, maybe because what law is the tenant not complying with in the use of the premises? Forget the activity that he's doing. He may be engaging in an activity that's not proper, but he's really not misusing the premises in contravention of laws. He's still operating a pharmacy which is licensed and zoned,
Okay.
right? So, yeah, it's a bad use, but it's bad at a different level.
But does the landlord have any, if it's a bad activity and it's kind of, and it hurts the reputation of the property because of it, even though it's within the zone, you know, it's not a CVS.
That's almost a morals clause.
Okay.
You know, if you're worried about that, don't lease to a pharmacy in the first place. And I can promise you that there are landlords, I won't mention any names, but they operate in Boca primarily, who would lease to anybody just to get the rent in, right? I'm picking on you, I apologize. I'm picking on him, because, anyway. Ooh, on my camera, but I didn't mention any names. So, I'm not mentioning any names.
What
What?
do you mean like?
No names. Careful. I'm not mentioning any names. There's lots of landlords like that. Okay. Most of them.
Turn off the camera.
The next thing in my outline. What'd you say?
I was beeping so you could start talking more freely.
The next word in my outline says, I don't know what this word can mean. Everybody seems to like this topic.
Do you like this topic?
What's that?
Do you like this topic?
Okay, so here's the story. Yes, I like the topic because, now I will tell you, I just did this recently for a Florida Bar webinar, and I've done this before for the Florida Bar. This is something that I kind of stumbled into as something to do because we have our law firm. Let me back up and do a little better introduction. What I'm going to talk about is leasing issues in the cannabis business. And our law firm happens to be one of the leaders in representing cannabis businesses nationally. It's just something that we got into because we have a tremendous background in regulatory issues, and we hired and opened offices with people who are nationally recognized in the regulatory side of the cannabis business. As you all know, it's become legal state by state in different places and different levels. In some places, it's legal, what they call adult use, which is industry talk for recreational. Other places like Florida, it's become medically legal and highly regulated. So what happened was, as we started dealing with these clients in states like Colorado and Oregon and California and Nevada, we had no real estate lawyers out there. And so while I'm not licensed in those states, I was able to help the tenants with the leases to negotiate the leases and go through the issues, while knowing that I had local counsel out there in our offices that could help with the local issues of law. So it kind of became something, and I talked to colleagues of mine. I go to national leasing conferences, and I was talking to colleagues of mine who have legal practices in Denver and San Francisco and Los Angeles, and none of their firms would touch it. It's, keep in mind that there's still this cloud, if you will. That was not an intentional pun. You'll know the intentional puns. Yeah, I like that. I'll have to use that again. There's a cloud over the industry because it's still federally illegal. There was a great meme floating around Facebook when the day after Canada opened it up for adult use, again recreational, and it was just a picture of the North America with a cloud over all of Canada. So it's just, yeah, I mean, sometimes, a lot of times they're intentional, that one wasn't, but I'm going to use it again. Okay. So what kind of businesses are we talking about? And what kind of uses are we talking about? Understand that the hardest part, and Florida is more restrictive because it is medical, and we are talking about very restrictive licensing. But the governmental agencies that are dealing in the licensing require the tenant to have site control. That means that they either have to have a lease, or they have to own a building, or they have to have a contract to buy a building in order to show that they have possession, or going to have possession in a good way, not the old way, and access to the property that's going to be licensed. So they also have to have a provision in the lease, in most of these agencies, where the landlord is acknowledging what the use is going to be. So you have to have a very cooperative landlord, because the landlord has to be able to sign a lease or contract and be willing to sit around and wait. It could be 6-8 months before the administrative agency issues the license and allows the tenant to go in there and operate. What kind of tenants are we talking about? Well, the simplest one is the dispensary. It's like your pharmacy. It's a retail use. It's a retail storefront. What?
I didn't own any pharmacies.
No, but it's your example, so now you're saddled with it. It's like my constitutional law professor when I was in law school would pick a victim of the day. He would come in, 8 o'clock class in the morning, which you all know how pleasant that is. He'd already been up and run 5 miles, and he would come in with a seating chart, and he'd go, "You." And he would start quizzing and asking the questions about whatever assigned cases there were. And I don't know about you guys, but 8 o'clock in the morning is not a real good functioning time when you're in college or graduate school. It just, I don't know, it kind of conflicts with the night before. Can I tell you? So you're my pharmacy guy today. So a dispensary is it's a retail use. However, it can be restricted by local zoning. Anybody ever hear the word NIMBY?
Not in my backyard.
There we go. Okay, see, my pharmacy guy knows all about this.
Pharmacist.
Don't assume it's gender.
So what happened, Florida's got statutes. I mean, this to me is fascinating because I never thought that this would be a part of my law practice. I mean, just over a long period of time and some minor experience in the area, but I just never ever thought this would be part of our legal practice, and it's a huge part of the legal practice because it's front page type of stuff. So there is a statute that talks about zoning and what the local governments are allowed to do. And one of the first easy things that this isn't going to surprise anybody, that you cannot have a dispensary, a medical marijuana treatment center, a cultivating, or anything within 500 feet of a school, an elementary, middle school, or secondary school. That's kind of like the same as a liquor store, I think, where it's probably, well, I think, surprisingly enough, what this doesn't say, and I'm not sure, I haven't looked at the other ordinance, there used to be ban, without getting a special permission, of having a liquor store too close to a church. Now, maybe that was because the church had a school, so I don't know for sure, but that doesn't, there's nothing in this statute, they probably can't, and by church, of course, it encompasses any religious facility, but if you think about it, most houses of worship that are of any substance have a school, preschool, or some kind of school, so it would come within the school requirement.
What happens if they build that after the liquor store is already there?
Grandfathered in. You can't, first in time, first in right. We go back to that. So, and that's always the case. I mean, that happens, you can't change the law and close somebody down unless it's something really bad. And that, sometimes that does happen and can happen with certain kinds of uses. You can change the law and alter the use without putting them out of business. For example, Oakland Park had something that, a strip club that served alcohol couldn't have full nudity. Something like that. And then they shortened the hours back that no bar could be open past 2 a.m. Things like that.
Was this the one on Federal?
Yeah. God, this is really a rough room.
The strip club guy, the pharmacist guy.
Well, and I know that one because my client bought it and tore it down. It's going to be apartments.
they made a Bahama.
No.
shopping there.
Well, that's one of them. That's
And then there's the other one right next to it. That's
about a
by
block
the
away.
sushi place.
Yes. 2 Italian restaurants in that building, in the Roselli building. Yes. So it's going to be apartments. Okay. So they then said to the counties and the municipalities, you can ban this. You have the right, and let me tell you, as soon as this law got passed, the cities came out en masse and they said, no dispensaries in our town, no dispensaries in our town, no dispensaries in our town. Lauderhill said, bring it on, bring it on. And Lauderhill, just like, boom, that's where they are. Because Lauderhill wants business. They need, their economics aren't great. They used to be a mecca of wholesale stuff. There were places you could go there for all kinds of bargains. There's something along 19th Street in Lauderhill. Back, I remember my mother used to go, people would go there, there was a place you could buy lucite for the condos. It was really the place. All the people would come down from Boca, or there were discount clothing places, but they all left because the population moved up into North Palm Beach County, into Mid Palm Beach County, those shoppers, so those businesses closed down. Lauderhill was one of the communities that said yes.
I heard something around the time like when we first voted for the medicinal use of marijuana in Florida, and certain like counties were saying, oh, it was only restricted to this part of the zone. That was not. It was like a bunch of contingencies, and then like come to find out, like that did not exist. Like they basically like made a bunch of contingencies of an area that did not exist anywhere in the county. So it was like there was nowhere that you could put.
They probably got thrown out. I'm going to tell you exactly why. So if the statute says a county or municipality, so now you're talking about the county or any of the cities, that does not ban dispensing facilities, may not place specific limits by ordinance on the number of dispensing facilities within that county, and then it says they can create ordinances and criteria, blah, 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 the same as pharmacies. And I don't think that applies to, say, a CVS necessarily, but like a real freestanding pharmacy. Maybe it does. I'm not 100% sure of that. But it says it may not enact ordinances which are more restrictive than its ordinances permitting or determining the locations for pharmacies licensed under Chapter 465. It may include the Walgreens, I'm not sure.
And then, even though the government may not restrict how many dispensaries, a lease signed by.
I'm going to get to that right now. Okay. So we talked about the zoning. I talked about that it's similar to liquor stores, being close to sensitive areas. There's also the problem, still, of public perception and acceptance. People don't want them. So, the first problem is a shopping center. Let's talk about a shopping center. The more nebulous problem is that the other tenants may be up in arms. They don't want a dispensary in there. Now that's not going to be true for Subway or Domino's.
Yeah.
But or Baskin Robbins or any of those kinds of places. If you think about it, obviously it's a good, a complementary use. That's correct. So that's one issue. The other issue that's much more serious is because of the federal prohibition, you can't have a mortgage. You can't, no bank, and they're actually, there's bills in Congress right now, so I'm gonna have to change my talk if it passes, which I hope it will. But as of right now, because it's still federally illegal, no federally insured financial institution will make a mortgage on any cannabis facility. So, one of the requirements of almost every mortgage is that you have to go and get the mortgage approved by your lender. Go get your lease approved by your lender. So, I had one client call up and say, not only can't you put your dispensary in this shopping center, because if you do, we're going to call your loan, but we're going to cross default every other loan you have on every other property you have loans with us with. Because the lender had a no violation of federal laws clause in their mortgages. So that's, yes.
So a lot of places now, like even just driving by, especially in like Hollywood area, there's always places that say like, oh, CBD or Kratom or like whatever. And how do those places stay in business or
That's
have
new.
like a mortgage? Because it's still a cannabis product regardless
They
of.
just changed it.
Yeah.
They just changed, yep, they just pulled CBD, because I was concerned about this too, and it's very recent. They passed the agricultural something or other bill in the last, I think it's weeks, maybe months. I think
Because it's hemp, right?
What's that?
Is it from
Hemp.
hemp?
It all comes from the same plant. So if it's below a 3% THC content, like the CBD oils all are, the CBD oils have theoretically non-euphoric other health benefits, back pain, relaxing, mental, whatever, but it's not euphoric. So it's different. For a while, it was kind of like gray market stuff, but now it's not anymore.
So how is this? Because remember the whole like K2 thing that happened? Like they're selling that at gas stations. How is that?
Like spice, like synthetic.
Yeah, like that
marijuana.
stuff. How is that? Like the CBD is that regulated by like the
I
agricultural?
don't think the CBD is
Because
regulated.
that stuff is like
It's
dangerous.
It's really because some company get
Yeah.
sued because the amount of stuff that they declare they have in the packages and the amount that or in a candy or whatever they sell them, it's not. It's way
It's like
below.
not regulated by the agricultural.
Well,
It's
it's in flux. It's definitely in flux. I mean, yeah, no, it's things are changing.
So if I was like an owner, like yeah, and like I leased out my building or my unit to somebody that runs like a smoke shop, and all of a sudden I find out that that smoke shop is selling CBD cartridges, I can't kick them out and say that that's not part of my lease, even if I had something about cannabis use in there.
Okay, interesting. Depends on a couple of things. Because you at the end you said what was in the lease. If it says something what you can and can't do in the lease. And by the way, there are in shopping center leases, you have national tenants in there. The national tenants are going to have a list of things you cannot do in the rest of the shopping center. One of them is a dispensary. But in that situation, your tenant's violating the lease for any one of a number of reasons. Number one, you might have, your lease might say tobacco products only. If it says smoke shop, that's vague. What are they selling? If they're selling an illegal product, they're violating something or another. So you could technically throw them out or say, stop or I'm going to throw you out. So now the question is, what are they selling? If they're selling cannabis with THC, that's illegal, clearly still. If they're selling the CBD oil, and the CBD oil is okay, then they're not violating anything unless it says tobacco products only, which it isn't. That's a zoning thing, it's a violation of the use clause.
No, because there is like also like I've seen now again like crazy stuff, but like it's like weed, but it's like CBD weed, and so it literally looks like bud.
It's just a marketing ploy.
Yeah, but again, it's like yes, it may be like technically legal, but anyone who walks in would see that and be like, hey, you're selling drugs.
Okay,
and
so
like how do you like argue with them that it's not?
all right, so number one, again, we're going to go with the industry term. The industry term is flower.
Yeah.
Okay, but that's what it is. It's called flower. Flower is not legal for medical use in Florida presently. So I'm going to get into the next kind of leasing, but there's a 25-to-1 ratio. It takes 25 pounds of flour to get 1 pound of oil. So it's one of the effects of that, and one of the reasons that there's lawsuits going on, is it's artificially suppressing the number of licensed dispensaries because they don't have any product. because they just can't get enough product. They can bring it in from other states and other places, but for the moment, for the medical dispensary, it cannot be flour. So I don't know what that is that they're selling, but you know, you can go into Davie and pluck hay and put it for sale on the counter. You know, there's nothing wrong with that. But if you go into the wrong field and it happens to be, looks like hay, but it's not, that's a different issue. All right, let me go on to the next type of use. See how much fun this is.
Everyone got so active. Can we all sit in a circle for this one?
The next thing after retail is distribution or wholesale. It's warehouse. It could be storage, warehousing, bulk sales to the retailers. In any of these things, you have some unusual issues that don't pop up in a regular lease. Probably the most important is security. You have two things going on that require some serious attention to security. Number one is you're storing a controlled substance, and you have to keep people away from it. And number two, because of the federal prohibition, most of these people are dealing in cash. So you have to be able to protect the cash. And that includes not only, when you think about it, not only at your facility, but getting it somewhere. Because if the bad guys know that your driver is coming to your place of business at 12 o'clock every Tuesday to pick up your bag of cash and take it somewhere, they're going to know that that's the car that's got the bag of cash in it, and that could lead to a problem. The solution is to hire a fleet of grandmothers in Priuses. So, where are these warehouses going to pop up? Well, again, when we talk about the zoning issues, they're going to find they might be in a community that wants to improve the community, so they're going to allow the use as opposed to other communities that have banned it. And so the warehouses are going to be older, a little dilapidated, and needing of work.
So I have a question, and this goes off of what the luncheon I was telling you about. If you're an owner, and here in the state of Florida, you can lease to these people, but federally this is illegal, how is the owner and the person renting getting away from a federal level in terms of like IRS money coming in?
I'll get to the IRS in a little bit, because that's a whole different issue.
Because isn't it
Right now, the federal policy is non-enforcement. And there is no money allocated to enforcement. For a while, there was something called the Cole Memorandum. And the Cole Memorandum was issued by an assistant in the Justice Department by the name of James Cole. And he outlined 6 or 8 bad things, like selling to schools, criminal activity, racketeering, things that if you did these bad things, you would be prosecuted, but if it was legal in your state and you didn't do any of these bad things, the feds were going to leave you alone.
Okay.
As soon as Jeff Sessions came in as Attorney General, he revoked the Cole Memorandum and everybody freaked, because we were expecting a sharp turn in enforcement. But apparently somebody wouldn't let him go nuts with it for whatever reason, because honestly, from what I've heard, we have a lobbying group in Washington, a lobbying office in Washington, and a lawyer in Washington that does some of this stuff. Congress doesn't really care so much. They're okay with this. And in fact, there are bills now, one bill to take it, if you get it off of Schedule 1, the FDA Schedule 1, which means it's worse than heroin right now. If you take it off of there, you solve the banking problem and the tax problem, and you're on the road to really normalizing it like alcohol. It's okay. So you take your old warehouse now, and it's been dilapidated, it's been neglected, and all of a sudden it's going to become a distribution facility, not retail, but you're going to have retailers coming in and out and people and doing things. And so in order for it to be functioning and licensed, the landlord's going to have to put some money into maybe redoing the parking lot, ADA access, Americans with Disabilities, to make sure that the entryways are accessible, that there's ramps where there were steps, that the bathrooms are okay. So this is all hard money that needs to go into the premises. Remember now that the landlord is signing a lease and agreeing to sit and wait 6 months until the tenant gets his licenses. So it becomes a question as to should the landlord do this and enter into this lease and make this investment in improving the property versus what do you put over onto the tenant? What you put over onto the tenant, I'm going to get into in the next type of use, but if you think about it, there's two things. One, these improvements, parking, access, bathrooms, all that kind of stuff, that's permanent, that's good for the building anyway. And because of the nature of the use, the rents are way above market. So the landlords are willing to do these things that improve the building permanently and are generic and could go for any other use. Next category, growing. Growing is an agricultural concept, basically. You're growing a plant. However, while here in South Florida, it would seem very easy to go sprinkle seeds in a field and grow it, it's not done that way. Not by professionals, anyway. It's done indoors. It's done in a controlled setting. So as soon as you start doing it as a controlled setting and indoors, it becomes industrial, not agricultural. So that's going to affect your zoning for the warehouse. But if you think about it, there are special needs to the facility in order to create an industrial agricultural growing facility. Well, by the way, what I'm talking about here would absolutely apply if you were growing coffee beans as well. But, so you need water, you need irrigation if you're growing any kind of plants. Anybody ever been to Disney World to listen to the land?
Yes.
Where you take you through the boat ride and they're growing all the gigantic vegetables and things? Well, they have all kinds of irrigation systems in there.
What
They'll-
world is this in?
What's that?
Which park is this?
Epcot.
Epcot.
Oh, you have to
It's a
be
boat ride?
Yeah.
Yeah. Super cool.
I've been to Epcot since like.
It's when it's next to Soarin'. When you're tired of waiting on the line for Soarin', you go to the boring boat ride. Anyway, it's actually kind of cool what they do because they actually serve the vegetables throughout the parks. Anyway, lots of water. Much more water than a normal warehouse use would ever use. And electricity. Much more electricity. I had one client, typical warehouse service, I think they said was about 400 amps of electric power. They needed 1,200 amps. That's just means more electricity, more service.
Three-phase?
Sure. 3 times as much. I don't know if that's what that means. I don't know if 200 is one phase and 400 is 2 phase. In which case, you're at 6 phase. So I don't know. Ask an electrician. I really don't know the answer, but I do know it's a lot more. It's a lot more money, and not only does it have to be done in the building, likely it has to be pulled down the street from somewhere. So now the allocation of risk and cost comes into account in drafting this lease. Now this is something that is specific for the tenant, and something that the tenant should absolutely be obligated to pay for. Whether the tenant gets its licenses or not, the tenant wants to know that it can operate if it gets its licenses, because as one guy said to me on the phone, he says, listen, I got to get this done because if I get licensed and open, I'm going to make $20,000 a day. Those were the words. That may have been, and just again, for strictly because there are all kinds of amusement involved in this practice, and I just can't help but share this. The same tenant, I was negotiating the lease about this time of year, and with all the improvements, he says, I really want the commencement date of the lease to be 4/20. They have senses of humor, I mean, you know. Okay, if you're growing, I mentioned this briefly, you have fertilizer. Fertilizer is a chemical. It's a hazardous material. Not only is it a hazardous material in that it could get into the groundwater, but I think it could blow up, right? So you've got to have specific precautions that require the tenant to take. Oh, and by the way, keep in mind, you can't get a mortgage on this property. You can't put an institutional mortgage on this property because it's federally illegal. You keep coming back to that. There actually are REITs, real estate investment trusts, that have been formed by some of the largest real estate companies in the country. Anybody hear of SL Green out of New York? Huge real estate company.
Is that a fund?
What?
Is it a marijuana REIT?
No. This is a legitimate, long-standing real estate company that created a REIT not to go into this business, but to provide financing for this business. I was at a conference in New York, and the conference was investing in the cannabis industry without touching the plant, because there's all kinds of businesses that want to be they don't want to be involved directly, but they want to provide the money. Anybody here a Corona beer? Yeah, a few nods. So Corona is owned by a company out of Mexico. Well, I don't know if they're based in Mexico anymore. Called Constellation Brands. They Corona, Maduro, Modelo. Thank you. And they also own a whole bunch of wineries in upstate New York, which is how they actually started in business. They made a $4 billion investment into a Canadian cannabis company. InBev just made it. Altria just made an investment. It's rolling. The more the big players get into it, and let's face it, I mean, as I've said a couple of times, it should never have been and it should not be any different than alcohol. Something happened probably right after Prohibition, back in the 30s, and it may have been driven by the original alcohol producers that wanted to make this go to the illegal side, because it wasn't illegal prior to then, so that to boost the alcohol production business. In fact, a little known fact, you hear me talking about the cannabis industry because that's the correct name for it. But back then, they called it marijuana because that was a foreign word. That was a Spanish word from South America, and it was bad. And that's honestly, that's where it came from. It's just a Spanish word for the same plant. But back in then, the people were ignorant, and that's what they did. Okay.
I think it had more to do with the textile properties of hemp than it with the pharmaceutical, because it was a big. I forget what company. I want to say Levi's, but whoever was big into the textile industry back then, it was more of a challenge to them on that front than it was on the drug front.
Means we can smoke our jeans?
Well, the hemp material was a lot stronger than
right.
cotton.
Sure. So right. Okay, because they used to make rope out of it too.
Right.
Okay. Besides the fertilizer, the other thing in the growth, pest control. Obviously, you're spraying for bugs because you don't want bugs in a professional agricultural setting, but that's another hazardous material. So, back to the fact that I am trying to talk about leases here, remember that you have to have exceptions for a lot of these things in the leases, because if your standard lease is, an exception of the hazardous materials, an exception in the general provision says you're going to comply with all laws, you have to say except for federal laws regulating this. Processing, extraction, for example. So I said you've got to get the flour down to the oils or creating the edibles. Well, extraction can be, there's different ways to do it. It is, of course, it's not only an industrial but a manufacturing use for the premises, so you've got zoning issues, same utility issues involved, but some of the extraction is chemical based and is potentially very combustible. Power requirements, all the same things, hazardous materials. Security issues. One of the most simple standard provisions you'll find in every lease is that the landlord's entitled to reasonable access to the premises. So what are you going to do? Is the landlord going to be able to come in and come into your premises where you have your cash box, and come into your premises where you have your inventory? Does the landlord even have the legal right, if he's not licensed, to be able to go in there? So it's a problem. You can't bank the cash. Anything over $10,000, you've got to fill out paperwork. There are payment services similar to PayPal that are operating in the western part of the country to kind of deal with these payments a little bit in a non-banking function. We're on the verge of having this fixed a little bit. So the landlord's access has to be limited to the cash areas where you're storing it, your safes, your offices, your counting rooms, whatever, and to the controlled substance.
I know you said like the grandmas and the
Priuses.
Yeah, no, I know, but isn't most of it handled truthfully like armored trucks, like the same Brinks style people would come and take the cash and put it in an armored truck and then
take it where?
Well, I don't know, but I know like
that's the problem.
I think like your offhand thing was just like, oh, like you'll get someone to take it, but like it's really not like that. It's like if you ever see the people come out of dispensaries, it looks like the SWAT team coming out with like barrels of cash. Like it's like a real Wild West scenario.
Because where are they going to take it? You can't put it in the bank in a normal way. That's the problem. And there was a bank in Florida that was taking deposits for a while.
First Green Bank.
Yes, that's correct. And I don't think it was. Yes, he's right. But I really, honestly, I don't believe that they were formed that way with that name, with that in mind. I don't.
I was guessing.
But you were guessing what? You
Yes, I could say First Green Bank, it's a marijuana bank.
Did you know the bank?
No, I had no idea. I promise, I had no idea. It was absolutely
Yeah, a little suspicious. I think he's been in pharmaceuticals. Okay. That wasn't in the bank. That's funny though. So again, the idea, yes, you could have the armored car, the regular Wells, well, not the Wells Fargo's. Wells Fargo's really, they are so against. They're the ones that said we'll call you a mortgage. They're just not nice about it in general.
What about Bank of America?
I don't know. I mean,
It would be
they can't.
un-American.
They legally can't. Okay, so you have a problem. Yes, you can have the armored truck. I don't know where the cash goes.
Yeah.
I don't know what's happening.
Like my I guess perception of that would be, again, if you have multiple retail locations, at some point, if it gets too much, like you can't just keep all the cash in a small retail place. They
Right.
probably have like a vault or a safe or a safety deposit. I
Well,
don't know.
remember, keep in mind that under the current Florida scheme, Florida anyway, you got the vertical integration issue, where the dispensaries are owned by the distributors that are owned by the growers. Companies like Trulieve that own everything vertically. So I just don't know what's going on with the money. It'll get fixed. It's going to get fixed soon. So you got to be careful. I mean, the landlord can be saddled with liability. If the landlord enters to exercise his normal landlord rights to go in, the tenant can say, hey, you took $300 off my desk, or $3,000 off my desk. And so I had a lawyer that I was talking to at one of my conferences. He represents jewelry stores in Manhattan. Jewelers, not jewelry stores. And he, in doing his lease, he absolutely struck the landlord's access rights completely. And I looked at him and I said, what are you, nuts? Every landlord has the right to go in. What if there's an emergency? Everybody would say, what if there's a fire? And so he said, the fire department will break in. They have an axe. The landlord doesn't need the legal right in the lease to come in. What's he going to do with a fire? They're going to call the fire department. The fire department's going to come. They have access. It's called an axe. So in reality, I know it sounds silly in some regards, but if you think through it, in any situation where it's this sensitive, why does that landlord need to get into the premises? He doesn't. I mean, the typical repairs, so the tenant says, I'll repair it. So, you know, it's so sensitive. It's so outside the box that you have to consider all the little issues. And I've talked about financing numerous times. It's a problem. You can't get bank financing, but there are sources. Talked about the federal issue. Okay, so there's always the problem that there could be a shift, a negative shift in enforcement. You never know. I mean, it's very unlikely, given what we're hearing out there, what's in the news and what's floating through Congress, but something could happen. And if there was a federal shift, then the tenant must have a right to terminate the lease. The landlord might say, I need a right to terminate the lease because I can't have the risk of a seizure. For example, the feds might say, again, unlikely, but the feds could say, you're operating this business, you're allowing a tenant to operate, we're taking your property from you. We're seizing your property, a RICO Act violation, something like that, because of the nature of the use. So the landlord should have the right, if there were a change in enforcement, where he put him at risk, to terminate it. Zoning could change. Oh, in doing improvements to the property, it may be necessary to find specialized professionals, specialized architects and contractors that know what they're doing with the security, with the growing, with all these other facility things. As I indicated, the application process is lengthy. It can also take a tremendous amount of time to properly design the rehabilitation of a facility and to have it renovated to the standard that's required under the lease and so on. So the industry's growing like a weed. The government agencies, sorry, I have to. The governments are overwhelmed, and it increases the delay. So now, what happens to the landlord-tenant relationship during this period? Bringing the building up to code, okay, that's the landlord's obligation. I talked about the improvements. That's fine. It can be used for other things. Even Halmos made a good comment about you have to be careful when you're building something for a specific tenant, that it can be usable for other things. For a long time, there were companies building health club buildings, and they were designed in such a way that without excessive costs, they could be converted to office buildings. And I think they were even multi-story, where they could do something like that. So that was set up in that way. Obviously, the specific premises improvements should be done at the tenant's expense, and it should be the tenant's risk. If they have to terminate, that's their cost of doing business. If the use is prohibited, change of law, again, the tenant's going to be stuck with whatever they spent, and that's their risk. It shouldn't be the landlord's risk, so there should never be a provision, as there would be in some kind of leases for termination, where one side would reimburse the other side for the improvements. Here, the landlord's going to bear the risk of the improvements, the permanent improvements of the building, the tenant, the specialized use risks. The landlord should also retain a right in the unlikely situation where they have decided to let somebody in and there is a mortgage and they're going to take the chance. If the bank declares a default and the only way to cure the default is to terminate the lease, the landlord should have that right reserved in the lease itself. Rent payments. I said I'd get back to the taxes. So the producers are calling it a penalty tax, but it's really not specific that way. It's really a quirk in the tax law where the income from the cannabis business comes under Section 61, which says the income from whatever source derived is subject to the income tax. Anything coming in, anything you're earning is subject to income tax. However, Section 280E of the Internal Revenue Code has a provision that says you cannot deduct any business expenses that are associated with a Schedule I prohibited drug, which cannabis is presently a Schedule I drug. This means that from an operating standpoint, you have to pay income tax on your gross revenue. You can't deduct your salaries, you can't deduct your rent, you can't deduct your office expenses. The only thing that you are allowed to deduct is cost of goods sold, which would be your seeds and your soil and your fertilizer and that kind of stuff.
Why the restriction?
What's that?
Why the restriction, though?
It was designed, I think it was designed actually in the early 80s, this 280E, not just for cannabis, and it was to get all the drug lords, the people that were trafficking in large amounts of illegal drugs back in those days, so that they couldn't write off. I mean, they were in business, so they filed tax returns to stay out of that kind of jail. That's what got Al Capone, if you recall. And so they were filing their tax returns. Here's my business, I'm doing this, I'm doing that. You can't catch me doing this, but you're not going to get me for this, 'cause I'm paying my taxes. The government said, okay, pay your taxes, but you can't deduct your expenses. So it puts them up at like a 70-75% tax bracket. That somebody quoted me that kind of a number. So it's a penalty, it's a huge penalty. And it's one thing for the guy that's going to have the cash and may or may not be reporting all of his income. It's another thing when you're talking about these large production companies that are legitimate companies, they could be publicly traded and they have investment. That's a problem, much more of a problem. You also have a cash issue with the landlord. Now, the landlord's going to get rent. How is the landlord going to get rent? If the tenant comes with a bag of cash, now the landlord's got a problem because anything over $10,000 requires a form. So now the landlord's at risk for that. The landlord needs to have a provision in the lease. I mean, these are all things that have to come back into the lease. The landlord should have to have a provision in there that it discloses to the tenant that they're going to file this form because it's going to talk about, it's going to be reporting what the activity is going on in there. Okay, time-wise. Take a little break?
Yes.
Sure. All right, let's do that. Just reload the water. If there's more. I hope this is interesting.
Yes.
10, 15 minutes tops.
Because otherwise.
I'm just saying. I denied you and I denied it. I'm just saying maybe I want a specific theme in my topic.
Make sure it's facing you.
Right?
That was the greatest guess you've ever
That's
heard.
what people definitely want to.
Yeah, confirmed. I thought he was just playing along.
No,
I started dying. That was close.
I was like, wait, does he actually know this?
Yeah, you know, I'm Floridian banking cannabis historian, and I understand the first institution to hold marijuana money. That's what a name.
I got so excited.
If you were to guess what the first one in Florida to hold, what would you call it?
That was the best guy.
That's what I'm
That was the
saying.
best guess. It was actually right. I think there's much like information on this, so.
I don't know why this really woke me up.
You see how I'm trying to back him into the question, like,
Yeah,
so do
yeah.
you like this topic?
I'm just saying, it looks like a lot of work.
Well, it's probably later, I mean,
Can you imagine how much?
Oh yeah, like it would be great, but I don't want to get into any like
it could be
legal
dangerous.
trouble.
It could be
Yeah.
very dangerous for people.
I'll just open for life.
I'll open it where it's legal. Fully.
Yeah, because here they're not allowed to sell like the actual.
I want no part. I
You
want
can sell
zero
the oil,
part.
you can sell the food, you can sell anything except
What do you think about hip? I couldn't understand what they were trying to say about that. I'm going in and out with him. But they have hip lotion everywhere.
Yeah, but 10 years ago it was not allowed.
It just recently was like formally legalized.
Yeah.
Oh.
That's why you see it a lot more now.
Oh, okay. That makes
Because
sense.
it was an issue. A lot of people in Boston were making hemp clothing, and there were hemp clothing stores, and a lot of them ended up going out of business at one point. But now it's completely legal in some places.
Dead. So are they coming
Oh
back?
my god, wait, I'm going to Boston in 2 to 3 weeks.
Here's like first stop.
Oh my
Or
god, I
second
didn't even
stop.
think about that. Oh my god.
Please get your car drop first.
Then to all the craziness, yeah.
Yeah, no, I'm gonna get it inspected first, but
Why
dear
did you get
God.
it inspected?
It's in Boston, if you don't pass safety and emissions, there goes your registration.
It never fails.
Is it the same thing over there too?
I know it's the same thing in New York.
Oh, yeah. Looked at our
You
website.
have to do it in New York, New Jersey.
GM.com.
I think, no, Florida does not
You
require
want
it.
to enter that space?
Georgia doesn't require it except for Atlanta.
I should have brought, I forgot,
That's
I
why you see
really
so
did
many
think
old
about
cars
this.
here that you're like, that's still
Because I had
running.
I had a
No,
couple in my
I'm
car.
kid you not, someone put together a car back like with zero knowledge.
Packs of
The
papers.
car's going, this is about to fall apart.
But that's literally, and it's
Yeah, I got
funny
3
because
lanes
it's legal
over.
here.
It's literally
Because
what I
they
did when I was
do
in New
not
York,
regulate
we had a
the
conference.
I was at a conference.
And I was like,
The bumper's about to fall off.
and I
My
said,
kids do
they made a
not.
bowl
I'm
with
like,
them, you know, at the kiosk, and I'm like,
duct tape does not save everything.
and so our marketing person
Let it go
from
at one point.
Denver goes,
Let it go.
oh, if they're makeup blotters.
Yeah, I'm not laughing. Cheers.
That's hysterical.
Yes, so why is it, if they're makeup blotters, why do they say slow burning?
Wait, what?
So, our marketing, I don't mind repeating this, but our firm is big into this from a regulatory standpoint. I was at a conference, a business conference, and of course we have a kiosk because we're providing services to the businesses. And there on the table is a bowl and they're little packages with our name, our firm name on it. They're rolling papers. I was hysterical. I mean, really?
Did you keep it?
Hell yeah. I know, I asked for them, I got a bunch of them, I've been giving them out to clients and friends who, first of all, remember the whole concept in marketing of any kind is name recognition. So even if they laugh, even if they don't use it, whatever it is, it's the concept.
Sticks into their brain.
Yes. It's the firm name, and it's a, bless you.
Thank you.
It's marketing, because whoever's gonna end up using it.
If, so again, part of the problem that they were criticizing because this was in New York City, and New York State doesn't allow flower either.
Yeah. Although you should have done the conference in Boston. It's
Are they
legal
full on?
there.
Well, so out west too. Our
And
main,
Massachusetts now.
Yeah.
our number one experts are in. We have somebody who's like a nationally recognized.
Oregon?
No, she's actually in Denver. There's one in Oregon as well, but Rachel Gillette's her name, and she's in our Denver office, and she just is known nationally for this. Travels all over. It's a budding industry.
But
I think that's all of them. What about?
attorneys always have the best, like, I don't know.
Well, no, there was
Yeah.
we had a thing going with a couple of us in the office. Every time somebody makes that kind of a joke, you gotta take a shot.
Oh wait, was that one too? I
No.
over my head. Oh, okay.
No,
Oh,
no.
okay.
That was it.
No, it's stuff like at this conference again. It was a business
You have to
conference,
go to the door.
and there's the vape pen vendor, you know, set up with a display of all the different
I'm not gonna lie.
Yeah.
products.
You can't piss
Oh,
me
ours
off.
is better than so and so's because ours will burn every last bit of the oil and won't waste any of your oils. Okay, I mean it's a business. I haven't been out west to see. I mean, there's, you know, God knows what dispensaries are.
I wouldn't last.
The edibles and all that kind of stuff.
Who?
You guys started advising on your clients on opportunities.
Yeah, because he's going on vacation.
I'm not competent. I have a tax partner in New York. that's-
Thing right now.
knows it.
Okay.
But again, you have to have a capital gain because the concept is that you are reinvesting the gain into the opportunity zone property. That's the concept. You can't just jump into an opportunity zone and wipe your tax out in 10 years.
No, I follow. So if you 1031, say you have a significant gain on a piece of real
Oh,
estate.
no, was it?
Then you'd want to move the boot,
So,
not the 1031. You don't want to defer it. You are, by the way, you are only deferring it for, right now it's 6 years. Because whether you sell resell or not, the tax on the deferred gain has to be paid by the end of 2026.
Yeah.
So that's a whole other,
Nuance.
that might get.
Also, have you heard of the issue? I took a couple of classes in my undergrad in historic preservation, and there's a really huge issue of eminent domain being used as a way to reduce property values.
To
Reduce property values.
It's funny, it's funny you mentioned that in particular, because one of the things I do, which apparently didn't work very well for you guys, but I, after being on the real estate certification committee, I got off of it, they asked me if I would pre-test, which means review questions that other people had answered. And about 2 weeks ago, I got 3 or 4 or 5 questions to review and see if I could answer them, evaluate the questions themselves. And one of them was on something called the Burt-Harris Act. I actually validated the question because it was so detailed and so specific, and the questions,
But also, it
like
doesn't show how
between
much.
A and
I read up on
B,
him
had
earlier
one
this
word
morning,
difference.
and I think he lost some
And
money
you
as
really
well.
have to be super technically knowledgeable of it, which this is not the purpose of the test, this is not for super technical knowledge. It's for, you know, real estate
That's when you make it big when you're an
specific-
IPO.
You have to be a real estate lawyer, you know, real estate
I don't know,
lawyer,
like, I
but not
disagree.
this very
Like,
finite
to some
specific
degree,
thing. So
Like, yes, like you
that, I
100%
believe
right.
that.
But, like,
Well, no,
what if
you
don't
don't
want
even
to
have to.
public
Yeah, you don't
because
like.
then it's like there's so much regulation that comes with
If
that.
you're
Airbnb
down
private
zone
still.
Yeah,
in such
like
a way that
I don't know, like
reduces
it's also like a
value.
lifestyle. Like you're under a lot more.
Right.
Like Elon Musk. Elon
Yeah, you have to
drove
disclose
by and, like,
everything.
got,
You have
like,
to disclose
You
everything.
were
You know
not
what I mean? Exactly.
branded.
So if it's private, you can live your
You
lifestyle
know,
a little bit
I
more.
got off,
Yeah,
obviously,
yeah.
Right there.
Because all the finances of the company
Condemnation
is put
and
in
then
public.
domain.
Like,
Yeah.
you think Donald Trump will
Purpose,
make
I
this?
think you talked about that.
Oh yeah, no, exactly, man.
We studied the New London.
There'll be like all the information on there.
Like, don't get me wrong, if you're Warren Buffett, yeah, they take your company public. But if you're doing anything that's like speculative,
Where
like
they still have.
Yeah.
people like can come under fire, like just keep it private. Try to be a better
There's in
person.
Savannah,
Like,
Midtown.
Oh, okay.
Yep.
I lived right by it.
Anything,
It's not
if you're
the
doing
greatest of
something, then
neighborhoods,
don't
but,
like attract
I
attention.
lived
Don't.
right by it, and there was a bunch of elderly people that lived in those
So wait, how old are you?
units. These are historical units that were built in the
Turned 28
40s,
Where'd you grow up
1930s.
Boca.
Okay.
The
And
issue
I
was
moved out when I was
then
20,
the
bought my first
city
house,
government actually put
and
down saying that
rented out the
eminent
rooms,
domain
paid the
is
mortgage,
safety reasons.
lived
So
there
instead
for.
of rehabilitation, they said, no, we're going to
I mean,
remove it.
good money, I
We're
started
going to
working on
provide
credit
you
when I was
just
18.
compensation
No,
by
who
providing housing and much further.
Somebody-
I paid your loan in 2012.
So they're
The house was
just
105,000. I
relocating the
negotiated
community
down.
and all of a
No, it
sudden
was
that
110.
area is now about to be
Negotiate down to
developed
105 because they had HOA liens.
higher.
And then from there, it's just a 3.5% down payment.
Apartments.
The sales price was like
Well,
4,000.
the New
I
London
saved up
case
4,000,
said
put it
that was
down.
okay,
Mhm.
which was
That-
really a
that sounds
surprise to a lot of
realistic.
people.
I didn't have 20%. No.
Oh, okay.
I definitely
But
FHA.
did you get a
So that's
boost for
something
your
that I
credit?
remember
I
experiencing
wish somebody had
firsthand,
told me that.
literally
What do you mean a
Because I
boost?
saw the
I
units
moved
there
here
for over a year, and then my last year there, they knocked them down. It
I
wasn't
wish
20
somebody
days,
told me
30
that
days.
my credit
all
is golden.
I don't know who I spoke to. I spoke to somebody else from Haiti really quickly.
You gave me, well,
And
something
they said that you
you
don't
sent me
have
off in
like
the
no
wrong
credit.
direction.
Like, they don't have
No,
credit
no, no,
systems.
When you said it was
Where I came from,
Yeah.
that's different than eminent domain.
Yeah,
I thought you had the cash redone.
condemnation.
yeah.
Well,
It's not like hard.
Yeah,
No,
yes,
we do have.
but it's a different
But
kind.
it's not as normal. It's not as like
It's not, it's,
Correct.
it's a cash money.
That's where I first
Cash money.
But that's
Yeah, so coming here
condemning.
basically is like.
Or, you know,
Condemning it
it's
for
not safe to borrow cash.
Correct.
One of the biggest, I mean, I don't know if you guys know, but we have a huge
Well, usually
problem
local
with
government.
municipality. And then the elite.
The eminent domain part,
No,
it's a taking, no, well, it's basic, it's usually done by the state government. It could be federal theoretically, if they were putting an interstate highway through.
Yeah.
So,
The next
the difference is,
the
the
national,
difference is
the
it's a federal issue.
they're like
They
from,
go
like you said,
basically-
they're like immigrants, but now like they were born there, but born to families that were not like
Haitian national.
That's
So
why
which
that's
means that
federal.
all the money, because they govern the food, they govern food, as soon as you control food, corn, and electricity, in a country.
yeah, especially as small as here. It's an
Exactly,
island.
it's
It's
an
not
island.
like it's not like the US. Yeah.
Therefore, they control that energy. Two thousand baht is equal to they have their own port and they.
You know, you're lying.
It's not really why, it's more about convenience. It's archaic. It's like, for example, when you draft.
Yeah, they're not like putting it back in the
It's not necessary.
This is one of.
What I heard, so we went on the
This is one of the biggest problems that they have.
so let me
They
just
refuse to face the problem.
I expected I was gonna beat up
Refuse
more of
to
this.
look at the problem for what it is.
can I ask
You know, we should be going around with it.
Burnout
You
was
have
this
respect
kind
for the
They help each other out. There's questions.
So I used to like my organization.
Yeah,
I used to a little bit. I used to talk to
I told the story the other day, except when you wind up driving up the turnpike, it's
Uyghur.
that's a problem too.
And even like Mo, he's a guy who just graduated from the program, like he had like some real estate back home. Like even the people that we have, that would have like these cabins, it was like they'd have like barbed wire on it. And it was just like the reality of like here it is, like this nice piece of real estate for like a military base just to have
like
it.
for example, my dad, both work in the education. My dad,
Well,
she's
is actually easier? What is actually easier?
I'm on one for trip and she has a school picture.
Yeah, it's a sensitive topic for a lot of people with, high mortality rate in that vehicle.
What my guys, I'm not crazy.
That's why it falls out.
Because we had a case. I don't know how to
I want to die peacefully.
like when you graduate from 12th grade in that's what you have.
In the sleep. Why is he driving? Oh, absolutely.
Definitely.
Way more people
This is
What I need to tell somebody is what happens here about 4:15. That a haze going across the road.
And that would be a quarter after 4. That's what
beauty in the
It's easy, man.
20 after, right?
Right.
Well, you did that. You already used that.
But like you said, my dad was
I don't know why I was making
although we moved here, the living out. The living out of the house is out. It's just like to speak to the customer to me or my brother. But it's not like
I'm actually looking at a copy
normally you're supposed to be about the taxes, but the system is not.
All right, shall we light up this discussion?
Wow. That was a smooth transition in. Yeah.
Hey, I got a million of them.
What do you say?
Please, let's do we light this?
It's too easy.
Do you want me to turn off the camera?
It's too easy. I really should have. Well, you were out of the room.
I don't know, we just had
The papers.
They're all right there.
No.
Her dad, that'd be crazy.
I didn't know it was on. It doesn't matter. It's our heartbeat. We have.
Yeah, I mean, I can sit here and talk to him. Really? Like,
I mean, it's so funny.
It's for the, because we do conferences all over the country. Okay.
That's some smart marketing. I will say, whoever came up with that process.
yeah.
Some people are think it's they have all kinds of marketing stuff. All right, folks, let's go back to work. I know a lot of this is amusing, and there are all kinds of potentials for humor abuse, and I understand it, but in reality, and all the joking aside, the growth in this area is incredible, because it is becoming, you see the charts when you go to the regulatory, but I think I mentioned I did this presentation in a slightly different format for a webinar this past week for the Florida Bar, and it was a two-part webinar. It was my part on the leasing, and then there was somebody who was a lawyer in Tallahassee who had worked for the Florida Department of Health that was talking about all the regulatory side of it. And when you see the trending, and you see what's going on and how many states are adopting this, it's becoming more and more of an industry, and so these issues are more and more real. The landlords, because of the nature of the business, are charging a huge premium over typical market rent, especially for properties that are in a less than desirable area. So they're willing to take these risks, the risks that the tenant's licenses are going to get delayed. Oh, I meant to talk about that a little bit. So at some point, the landlord's going to get tired of sitting there not getting any rent and having the property off the market, because not every one of these licenses gets awarded. I mean, these operating tenants have to apply to the state, but they don't always get it because it's a competitive process. So in some situations, the landlord and tenant will work out a reduced rent. A rent where, say, they're going to pay half the rent or 20% of the rent after, similar to an inspection period or a due diligence period, or an all of the above period in a contract, where you have like a free look for 120 days or something like that, and then the next 120 days might be at half rent. That gives the tenant the opportunity to get to a certain point in their application process without coming out of pocket, and if it takes longer than that, then they're going to start paying the landlord some compensation. Sometimes it could be as simple as just paying the landlord's taxes and insurance costs, so that while the landlord's not making money, he's also not out of pocket having it empty. It's all economic. Unfortunately, when I ask my regulatory people, when I'm involved in a transaction, how much longer is it going to take? I have a closing pending right now, where because of the fact that it's so difficult to get space in a typical retail type of environment, this one client is buying, maybe it's a closed up restaurant, something like that. It's a freestanding building. So they have it under contract, and for whatever reason, whoever negotiated the contract, because it came to me signed, the seller didn't demand an outside date. So it's open-ended. So as long as it takes to get the regulatory things done, I get a call every couple, say once a month, from the title company that's representing the seller saying, any progress? When do we think we're going to get approval? So I call my partner that's doing the regulatory application. He says, we have no idea. They're just moving slowly. There's so many applications, and they don't have a projection. It's ridiculous. So, in addition to that vagary, the tenants are looking for things that they don't know what's going to go on in the business. They don't know if they're going to get, they could do wonderfully, and it's going to be a long-term thing, or all of a sudden the big if the environment changes and the big players swoop in, and by big players I mean like the InBevs and the Constellation, Altria just jumped into it, cigarette maker. If they come in, these little operators are going to be out. Maybe they're going to sell out their licenses, maybe they're going to sell out the dispensaries, maybe they're just going to get pushed out of business, unfortunately, which is what happens. So the tenants are more likely to ask for a shorter term of lease with more renewal options. And again, it's negotiation, but if the rent is high, the landlords are greedy. That's what happens. I mentioned the termination provisions in passing, but there's a bunch of different reasons why a tenant would require the right to terminate the lease. One, it would be the change of enforcement policy. Again, as I've said a few times, hopefully unlikely, but it's possible. The state, we've had our new Attorney General in the state of Florida happens to be against it, while our agriculture commissioner is in favor of it. So you don't know. I had an opportunity to meet Ashley Moody when she was running, and she had some interesting things to say based upon the fact that she had been a circuit court judge in the family law division and had seen all kinds of alcohol and drug abuse situations. So she was against liberalizing the cannabis laws in Florida. She's now our Attorney General, so she could put pressure in a negative direction. I don't think so. It doesn't look to be. I don't think DeSantis is going in that direction at all. But it's always a possibility. So the lease has to provide for the possibility of a change in enforcement at the state level or the federal level. You have to. There could be a raid. There could be a situation where, in order to make sure that the regulations were being adhered to, or if the regulations were being violated, whether it's the smoke shop that's selling some gray market in-between product that maybe CBD based, maybe it's got too much something. What remedies would the landlord have if there was a raid on the place and the government shut them down? Somebody's got to have a right to do something and to terminate the lease. I talked about the inability to obtain financing. There's also the other end situation where you get your license, you're operating, and you do something wrong as a licensee, either as the way you're operating the business or the person engages in an improper activity, the license gets pulled. In that circumstance, while there should be a termination provision, perhaps, should the tenant suffer the consequences? Should the landlord have to just live with a terminated lease and no recourse? Or should there be something like liquidated damages provisions or something that compensates the landlord, because in this case it's an at-fault situation, going back to the concept of the bad boy guarantee, if you will. The landlord should maintain a right to terminate if there was a material threat to its ownership. Like I touched on briefly, a possibility of forfeiture. Now, let's say the lease gets terminated, either because of one of these contingencies failing, or it's just the end of the term of the lease and it's time for the tenant to move on. Many leases and many landlord-tenant situations have a provision that say that the tenant can take its furniture or it's showcases, it's trade fixtures, and everything else remains the property of the landlord. Well, here we're dealing with controlled substances. Maybe we're dealing with inventory that gets left behind. Maybe we're dealing with specific equipment used in the production or extraction that, if you're not licensed, is illegal to possess. Because remember, even though the state has passed laws authorizing licensed people to deal in the product, that doesn't mean that anybody can deal in the product. So, legally. So that if there's a landlord goes in there and tries to retake possession of the premises, and the premises are full of controlled substance, or equipment to make controlled substance, there's got to be some provision to get rid of it. Well, it's not quite the same. There's a situation where I've had landlord go in because a physician, I don't know if the physician passed away or just defaulted on the lease. You go in there and the file room is full of medical records. Well, you can't just toss them in the garbage. There's HIPAA and there's all kinds of regulations of what you have to do. The landlord's hands were pretty much tied. They had to get somebody to come and take possession of these things before they could retake possession of the premises and re-let. So it's an issue. In the drafting of the lease, the default provisions have to have some kind of a specific provision that a violation of the state and local laws dealing with the cannabis use and production is a specific default. The tenant is going to want the right to cure any of these things. More cure rights than a typical default because of the fact that their license is tied to the facility. Leases, I don't know if did I discuss the stress for rent? I tried to not get too deep into the default. There's provisions where the landlord has a lien on the tenant's property, so that if there is a default, a financial default, the landlord has the right to go and seize the tenant's property in the facility and under a court proceeding sell it to satisfy the rent arrearage. There needs to be an exclusion in these kinds of leases, again, for the cannabis inventory and the cannabis-related manufacturing equipment that you can't possess. So, okay, so back to the tenant improvement situation. I mentioned briefly that the landlord would be obligated to do things like parking and ADA. Other things that might be on the list that the landlord should be obligated to do because it improves the building, cannabis related or not, and it might be necessary for the business, but it should be the landlord's obligation. What?
Fire safety.
Absolutely fire safety. That's code, that's typical building code, like anything life safety, yes. Water heater, laundry, sink and things for that, emergency lighting, the wall, again, keeping in mind that you may be talking about what would technically be called a dump, and you want to fix it up so that it's up to code and functional. Walls and ceilings insulated to the current code.
Egress.
What's that?
Egress.
That's safety again. I'm talking now about some improvements. White box, vanilla white box type of improvements. The walls finished. You know, you go into a warehouse and it's going to become retail even, or if it's going to be distributor, there may be no interior walls, or there may be studs, or it may be damaged. Landlords should be obligated, you know, you're negotiating back and forth, but to make the place functional, not for the specific use, but back to normal. Walls, I mean, drywall painted, things like that. In a warehouse, warehouses need to have usually an overhead roll-up door and 2 pedestrian doors for egress and egress, and they should be functional. The electrical service, I talked about, that's a tenant issue. The lease should also provide that the landlord will cooperate with the tenant, because sometimes with the certain kinds of property-specific permitting, you need the property owner to sign off on things without changing the zoning or doing bad things. If there are specific things that the tenant is going to do that would improve the property long-term, then the typical lease provisions regarding tenant improvements need to be altered to say that the tenant is going to either remove the stuff that they have to remove and repair any damage. So if you have, let's say you're in a room like this, and it's going to be a grow room, and all of a sudden you tear out the drop ceiling and you put heavy-duty piping across the ceiling mounted to the concrete deck above to put the heavy water in, then the tenant should be obligated to remove that and to patch up the concrete deck. Again, you always have the problem of the tenant not performing in a situation like that. If the tenant is not financially responsible, you go with a bigger security deposit to make sure of things like that. Because as you heard earlier today, that personal guarantee is only as good as the person who signs it. So, you know, if you can sign whatever you want, but if you don't have the money, but if there's the money in a fund, then you know you're okay, even though the money may come from a source. Talk briefly about parking, which is of course different for agriculture, distribution, retail, manufacturing, retail being the most parking heavy.
Per square foot.
They're all measured on a per square foot basis.
Even like a big facility with a bunch of people?
Well, it depends, because big facilities with a bunch of people may have a bunch of cars. So, but it's the parking ratios are going to vary by use. And it's easy, I can talk about it a little bit now. So, an office, a standard office, usually requires 4 parking spaces per 1,000 square feet. A medical office usually requires 6 per 1,000. That's just how the zoning works. A warehouse, you're going to have boxes on shelves. The boxes don't usually drive themselves there, so they don't need a place to park. A restaurant has 2 parts to the restaurant: customer seating and food prep. So the square footage is broken down in the zoning code that it's so many per square foot of customer seating area. And there may be some add-on for employees, or it may all be combined into one. So zoning does govern that, and it's all by the use. Now when you say a bunch of people inside, that sounds like more like a manufacturing facility. So a manufacturing facility is going to require different kinds of parking ratios and different parking requirements. But remember, you've got machinery and equipment that's taking up floor space. So that all comes into play. And I didn't prepare to go through the zoning codes, but every municipality has different codes. And of course, within those parking spaces, you need to have handicap parking, ADA compliant, including not only regular but van space parking. All things that take up land around the facility. So if you have a distribution facility that you're not accustomed to having these things, these are all improvements. But these are all improvements that stay with the property. So that's not a problem. Sometimes you have to pave it. Some of the older warehouses, you approach the warehouse and it's gravel parking. You can't have that with ADA. That's a lot of money. It's got to get brought to grade and paved and things like that. All landlord side.
Is that all over, or is that just in Florida that you can't have it paved?
Well, the ADA is a federal requirement.
Yeah, it's a federal.
I do not know what the specific requirements, but if you think about it, the whole concept is if you have someone that needs assistance to walk, whether it's crutches or a wheelchair or something, I would have to think it's got to be a solid surface that you can't have gravel.
So many different rural areas where they have a newer construction, but it's still all gravel.
Even the ADA parking?
Yeah, they have the little ramp, so it's ADA.
Then maybe it's compacted then. Maybe it's compacted gravel.
Yeah.
Because, it certainly would impede a wheelchair if it was loose gravel. So everybody understand we're talking about ADA, the Americans with Disability Act, and accessibility to premises? I did go over that a little bit. Access we talked about. Oh, insurance. Back to insurance again. Fascinating topic. So insurance policies, like mortgages, probably have provisions prohibiting illegal activity, because insurance companies tend to be national companies. So what happens is now you've got your extraction facility, your manufacturing facility, and it goes boom, because somebody mixed the fertilizer chemicals with the something other chemicals and the place blows up. It's okay, we have an insurance policy. So you go to make your claim for the insurance policy, and the insurance company says, cannabis, that's illegal. Clause 46C(a)(1)(2) says, we don't have to pay you if you're making weed. So all of a sudden, boom, the whole insurance policy goes away and the landlord's out of building. Not to mention whatever the liability claims. So it's very important to examine the insurance policy and to modify the insurance provisions of the lease to provide that the insurance will specifically not prohibit this. Probably difficult to get business interruption insurance for this. Maybe the rent abatement insurance that we talked about might be available, but again, it requires a specific conversation because it's a problem. Also, the fact that you're handling hazardous materials in the manufacturing, and beyond that, what about the cash? I mean, there's probably exclusions. Most insurance, even your homeowners policies or renters policies, if you look at them, limit the amount of liquid asset, cash, jewelry, things like that, by specifically. So if, because of the nature of the business, you have a strong box or a safe that you keep $100,000 of cash in, because that's how you're doing business, that may not be insured. So while you might be able to keep the bad guys out, think about it. In my example, where the fertilizer blows up and the money burns, you're in trouble. It's probably not going to be covered. Talked about the pesticides. Oh, it's not Florida specific, but I did have a note here. Oregon has a very specific list of what kind of pesticide you can use in cannabis growth, because it has to be organic, has to be stuff that, because eventually the concept is you are ingesting it. So remember, if it's controlled, if it's permitted but it's controlled, I believe it's controlled as a drug, but it's still, the production of it has to be such that it's safe for consumption where it's legal. And the neighbors might consider it to be a nuisance. You got to worry about nuisance provisions in leases and adjoining leases, where situations, well, okay, you're bringing the wrong element in here. You bring in these people that are coming to buy this horrible substance.
So who determines what schedule goes up? That's the Justice Department, Agriculture?
FDA.
FDA. So
Federal Drug Administration. Sorry, I'm going to acronym people.
So all the products that are getting consumed right now at any cannabis facility are not FDA inspected? Or are as a Schedule 1?
Well, there could be state inspections. It could be state level, because Florida, like for example, Florida has the Florida Department of Agriculture.
Nikki Blake. Or is that the commission?
Nikki Freed.
Freed.
Yes, and she's pro, but that's not important. But they may very well have, because I believe that's the department that's doing the licensing. So, they're the ones that are issuing these licenses and saying who can do what. So yes, the quality of stuff is going to be inspected.
Okay. If it wasn't the FDA, it would be state.
It would be state. There would be a state level. I think I've run out of weed. Any other questions? Anybody? No?
When's our final?
When? Oh, I'm glad you asked me that question, because
Right
when
now.
is right now? When would you expect the final to be?
Weekend.
Last class.
I mean, were you the one that asked about when's the midterm? Somebody asked me when the midterm was. I said in the middle, and I wasn't being trying to be right. So like,
I just want a constant countdown. That's
What
it.
the midterm is. There's 8 weeks. There's no real middle.
well, I did it I think I did it the fourth week, didn't I?
Yeah.
You're kind of in the middle of class too, to your credit.
Finals.
To your credit. It was kind of
Because okay, so here again, same issue we had. What the request? I came in and I took a vote.
We got no issue. I'm
Okay, no. I want to talk about this a little bit.
What's the issue, bro?
So the final will be the last class, the 8th class. I decided that in addition to the multiple choice, I'm going to use some true and false as well. I am not going to do any essays, don't worry.
And a study guide?
What's that?
I said, and a study guide?
Yes, the study guide is the notes you're taking in front of you.
Okay.
That is your study guide. That we talked about specifically, right?
No.
Now, I did decide to reverse myself on something, but only at a minor level.
Okay.
And that is, I might recycle a few questions. Not too many, probably not more than 10. But I might pluck a few of the questions and reword them just a little bit because I want to give you another crack at them.
But not from the, was it 6 or 9 that you had, that you took out,
No,
right?
he is talking about them because another crack after.
Oh, are you talking about those?
And I got a lot of those questions right the first time. So.
Okay,
Okay,
nobody's
Ryan.
talking about you.
A lot of easy ones.
I'm going to decline to answer both of those questions.
Thanks, Ryan.
That declining means you've answered the question.
Well, if you're perceptive, it's possible.
So
And the reason that I'm considering, I haven't made up my mind yet, but to answer this question, to make it a little more specific, was, first of all, I spent a lot of time going over them afterwards and what was wrong with them, so they're relatively fresh, okay? So, which means we've gone over them twice, maybe 3 times. I'm not gonna say every single one of them, but I think the fact that we've rehabilitated the question and gone back over the subject matter is I want to try and give you another crack at those issues, and I'll rewrite the questions to clarify them a little bit. The true and false is because I just figured, okay, a little bit of variety will help. Again, with a very few exceptions that I've given you some warning about, I'm not going to look for specific dates and times and things like that. You know, but I was very clear about one thing in particular that has a name to the number of days, that the notice even has a name.
3 different.
Yes, correct.
What
Okay?
about the 280E that you talked about today?
That's federal taxation. That's federal tax. The concept maybe. The concept that because remember, we're still, the concept could be, so a question could be true or false. A cannabis operator can deduct its rent payments to the landlord on its federal income tax.
False.
See? No, it's not hard. I don't have to say 280E. It's the concept that's important. I've tried to be as practical as possible without squeezing down to the minutia. And if I'm not doing a good job, holler, because you know that's what I was worried about with the test answers, especially the ones that I didn't like the way they were written.
Holler during the exam?
No! There's 2 things you cannot do.
I don't like this.
There are 2 things I'm going to request that you don't do, okay? Thing 1, don't come up to me during the exam and ask me a question about one of the questions. That doesn't work, okay? Thing 2, multiple choice and true and false answers are, you select one of the answers. They differ significantly from what an essay exam looks like. In an essay exam, you write out thoughts and statements about the issue, okay? You don't do both, okay? It's not necessary to do both. You know, it's not like a math problem where the professor says, show your work.
I like that.
No. If I wanted that, trust me, I can write an essay. I know how to write an essay question. You would not be happy. Almost as I would not be happy grading them. I have done that. I've done that with certification.
So there's no making some people happy.
Multiple, right, see, that's why I'm mixing them up. I'm mixing them up. Now, here's the bad part. Some of the true and false I'm pulling out of the textbook because we've gone over the information, but I got lazy. So I went back in because I have this professor's module that came with the textbook that I can go and pull questions out. But if they're too obtuse, I'm changing them up because I'm not doing that. It's not my purpose. I want to be able to go big picture on stuff.
But it's stuff we've covered in class.
Yes,
right?
absolutely. No, I made that clear. The textbook is supplemental. Any other test questions?
Do you have any test questions?
What do you mean?
Like to give our way?
Sure, what would you like? What was bad?
I don't know. I think there's a lot.
Anybody have any particular issues with the midterm?
It just felt really long.
What's that?
It just felt really long.
So it was 45 questions
Like that
for 4 weeks.
Yeah, no, it's,
You
don't want
that.
that.
That's what we do with other
because
towns.
last seat's going to work way more. Yeah.
So remember,
It's just, it's.
so mathematically, the way because I was asked to assign, how much for the midterm, how much for the final, and I said, can I give something for class participation? So I made that 10%. So I figured if there was 45 and 45,
That's 90.
it's kind
That's
of
one.
easy, right? That's the 245. It just happened that, honestly, I've been trying to come up with questions after each session to stay as relevant as I can. You know, you think this is easy?
You write like
I
an
mean-
essay or something?
What's that?
Is there like essays you can do?
Yeah, it's
want
all
one?
us.
I love writing essays.
You're reading them.
Wow, you
Writing.
thought I was the least favorite person.
No.
Aaron, take the role.
I made an option, like an
I
option.
love
There's now going to be a riot.
Yeah. Go.
You know what we should do? A 5K. Everyone wants to do a 5K.
Wait, 5K?
Now, I will tell you, I did give some thought to something, and I don't mind throwing it out because I'm not sure, I haven't made a decision on this yet.
Extra credit?
Yeah.
Yeah. How about an essay? No, please.
No, no, no.
Let's relax.
That is exactly what
Do research.
Yeah, current event, I think.
Current event,
Case
yeah.
study.
Spelling
That's
bee.
what
Study.
graduation. It's called a case study.
How about a day where you're gonna blend the shadow?
Brings it down, brings it down.
Let me ask you a question. Okay, so it's a funny thing, but so you say, you've watched TV shows about lawyers,
Yeah.
right? Have you ever seen an episode where Joe reads a contract?
No.
Okay.
Okay. Come shabby on that day.
I don't, so
3-hour episode, just.
I can talk about loan documents more. All right,
Will that give
so,
us
That's the
extra
YouTube
credit?
videos.
what's that?
Will that give us extra credit?
Oh, I'll put you to sleep.
Uh,
Okay, so,
What if
again, I'm
those
not,
that don't
I'm-
fall asleep get extra credit?
well, that's what happened, because if you got questions right, that's what I did. I made sure that even the people that got the invalidated questions right got more questions than the people that got credit for them being invalidated. That's how I worked
I
that
have
out.
like a legit idea though that you guys can.
I'm listening.
Okay, how about a contract and you'll leave in blanks and give us like a word bank?
No, please stop.
That's sick.
But like 10 actual defined words instead of memorizing the
Let's hear
definition,
yours.
just,
Let's hear your idea.
No, but honestly, my idea was to come up with a short essay question where for completely extra credit, so that if you missed a lot of the multiple choice and you wanted to make up for it, I don't know what I would give you, maybe 10 points of credit for the one, something, I don't know, I don't want it to be too long for 2 reasons. I don't want you to be spending a half an hour writing it, and I don't want to have to read that many of them. It's not, I mean, honestly, and it's very subjective. It's having done it, it's really not an easy thing to grade. It's one thing to read an essay and say, okay, is the person getting these concepts? Great, give them credit. This person doesn't write well, but I can forgive them because they have the concepts. Or, really? That's the third category. And unfortunately, when I was doing it on essays that were written by practicing lawyers who had practiced a long period of time and were specialized in an area and were sitting for an exam to certify them as specialists. So it was, when the essays were bad, it was like, wow. It was disturbing. I'll just go that far. It's one thing if you're not used to writing essays or not used to writing generally, maybe you're in more of a quantitative schooling, and essays aren't your thing. Not everybody has the the felicity of expression, to pull a phrase out of an old play. Anybody ever see Ragtime? No. It's 1776, sorry. My family's very into theater.
I've heard of it.
No, nobody's ever heard of it.
I actually have heard of it.
Okay.
It came out so.
No. It's literally about the founding fathers and the Constitution and all that stuff. But again, I wouldn't have expected very many to know of it. So that was just a thought. I'm not sure I'm going to do it because, I mean, when I came in here with the exam for the midterm, the number of fear was just disturbing to me because it's not my intention. But so again, my question was: there anything horrific that was in that exam, or the way the question? Okay, I mean that's. Don't look with that face.
Sorry, I was thinking.
Stop.
But if you were to do an essay for extra credit, it would be like a topic, like how we're doing now, like candidate topic.
I pull a topic. I
Would it
pull
be an
some.
essay
No,
or a
wait,
short answer?
hold on. It's not freestyle. I would ask a question.
Right.
Okay.
But it would
It's
be
not
on a
freestyle.
topic that we covered.
Absolutely.
That we can talk about more or less broadly.
Like a memo. Can we just write a memo? Is that
No.
brief essay?
Memos are bad.
Is it a short answer or
Yeah.
an essay?
Short answer.
You want to get like half extra credit if you write a short answer.
Short answer.
I think it comes a lot of like.
Because a short answer is like a paragraph.
No extra credit points if it's
But an
under
essay.
the times.
No, I would prefer.
That's what's called a slanted question, which is good. I'm gonna think about it. All right. Don't fret over it because it probably won't be a long one. Even though I know that I'm sure there will be eloquent people who will stretch the length of the answer, but it's okay because eloquence can be rewarded if it's right. Although there's another way to write an essay and it's called using a shovel.
The other way to do it is in as short of words as possible, so then you don't screw it up.
Absolutely.
The more you write, the more easier it is to screw it up.
In some circumstances yes, in some no. Because I will tell you, when I made a transition from business school undergraduate to law school, in business school you're used to answering a question with a finite answer. When I tried to do that my first quarter of law school, I saw a letter I had never seen on an exam before, and I was mortified.
Like an E.
What? Not quite. No. But
He said it wasn't
Because
an
you
E.
can't, you have to be detailed in law school, right?
well, you have to. They want issue spotting.
Right.
They want you to ramble on about what the issues are. They don't want you to answer the question.
Sounds like criteria or something like that.
Well, no, it's not. It's issue spotting. So it's not so easy. So I'm trying. I am also trying not to shortchange anybody class-wise. I know I haven't heard anybody complain about getting out before the 4:30 hour, but it's a little early. I can go on to the next topic, or I can do whatever you want. I can because I do want to. You know, part of the syllabus stuff I was going to talk about some taxation issues, real estate taxation issues. I definitely want to talk about what to do in the downtimes and how to protect a little bit about that.
I
I can.
could cover that today because we went through that already.
Well, I can talk about because some of it ties into.
That's still the candidate.
What's that?
That's still the candidate.
No.
Oh.
But it does relate. It does relate in some part to leasing. Because when you start talking about real estate investing, remember you're talking about income-producing property, which means tenants paying rent. That's good. Okay, you want money coming in. That's how you justify any investment, is money coming in, return on your investment. So when the market starts to turn down, or there's an economic downturn of any kind, that economic downturn is not limited to the purchase and sale value of the property. If the economy is going to go soft, it's going to go soft in a bunch of different ways. So what happens? What happens now when you have your brilliant restaurateur whose business is off 30%. And he's leased this 6,000 square foot restaurant space from you, and his business is off 30%, and he's struggling to pay his bills, and now he's 2 months behind on his rent. And now you at the landlord are not getting your cash flow, and for an example, he's paying you $6,000 a month, and he's having a problem. You can pound on him as a landlord and try and enforce the lease, and the likelihood is you'll drive him out of business and you'll have an empty space. That's not good for anybody. What do? Well, it's a little bit difficult in like a restaurant setting to suggest that he give up some of the space or sublease some of the space, because it's not easily divisible. It does depend. Like I gave an example of the sub shop where they took extra space for additional seating. So if you have a restaurant that's expanding in bays in a shopping center, you might get them where they say, okay, like there was a restaurant over on 84 in Hiatus, a diner, and they just kept taking more and more bays and expanding their dining room. Well, if one of the dining rooms closes because they don't have the business, they might be able to give up a bay to the landlord if the landlord can re-rent it. Now, you got to be cooperation on both sides, because the landlord is releasing the tenant in that situation of an obligation to pay rent for a portion of the space. A more practical way in that kind of a setting would be to reduce the rent, defer the rent. Instead of, I'm not saying write it off or get rid of it, but I'm saying, okay, tenant, you owe me $6,000 a month and I see you're struggling. Pay me $4,000 a month for the next 12 months while your business improves. At the end of the 12 months, I want you to not add on the $2,000 a month because you're going to get smashed again. I want you to start adding on $500 a month and start to pay back the deferral that I gave you over the next 2 years. So that kind of a deal would...
Fair.
What's that?
I said that's kind of fair.
It's very fair, and it keeps the tenant in place paying maybe not as much rent, but paying rent.
Yes, exactly.
Which means the landlord's getting cash flow. The landlord is not having to pay commissions to bring in a new tenant, if you can even find one in a soft market. They're not having to pay tenant improvements, and they're not having to give free rent again. Because remember, there's an economic hit to a landlord to bring a new tenant in. Maybe that new tenant's a great tenant's going to pay lots more rent, but in the beginning, it's a hit. So, in a case like that, where it's not divisible space, that's one way to do it. In a retail setting, or more so in an office setting, you might have the expanding, and it happens everywhere. So let's take the expanding law firm, that they keep growing and growing and growing, and something happens in the economy, and a practice area is not doing well. I hate to admit it, but it could happen in real estate, okay? And it's happened to law firms in real estate, where they grow, and all of a sudden the real estate market does the dip, and they don't have the giant developers coming to pay them tens of thousands of dollars for each transaction. Their revenue decreases, lawyers aren't producing income, and the lawyers are leaving or being let go because they're going broke. All of a sudden, they have these 4 floors of space, and now 1 floor is empty. So what are they going to do? In that situation, the landlord can be lenient about subletting rights, so you're not letting the law firm off the hook. The law firm is cutting some of the bleeding. I will tell you, when we first opened up in some of our markets that we went into, we sublet other people's spaces. We had a great deal in Manhattan, way below market, because there was a law firm from DC that was pulling a little bit out of the New York market, and they had half a floor empty. So we got it for like half of what the market, and in New York that's a significant number. So you help both sides again. The tenant's not going to default, because they're being allowed to at least augment their cash flow with some subleasing, even though the landlord might otherwise be giving up the right or the ability to take those subleasing tenants and put them into other space. But that tenant might not be willing to pay $75 a square foot for the prime space the landlord has, but they'll pay this struggling tenant $40 a square foot to sublease a portion of their suite. There's no tenant improvement, there is most likely commissions on that deal, no improvements, no abatement of rent, everybody's a little bit happier. So that's a sublease. Sometimes the liberalization of the assignment rights. The tenant finds somebody that can take over their lease, and where the landlord might otherwise not permit that to happen. In a downturn, you have that kind of a situation. So that's what you can do in working with leasing in a downturn. Banks, mortgages. Remember, we talked about over-leveraging, the comment was made earlier. That was great, because I told him he gave me great material to work off of a little bit. So, now you have the unfortunate situation where the tenants haven't survived. And now your property is down to a 60% occupancy rate. And you're struggling, and you can't make the mortgage payment. Now I'm on the landlord side of it. Now we're on a completely different side of the circumstance. We're the developer, the landlord, the project owner, whatever you want to call him. Now he goes to the bank, and he looks to the bank to say, what can you do, bank, to help me? Because, believe it or not, unless you're dealing with Snidely Whiplash, the bank is not looking to take that property. Things are bad. Other developers are walking away from their property because they can't make their payments and they're just giving up. The properties are going through the foreclosure process, which takes 6 to 8 months and costs the bank money, and then the bank gets the property back and has to deal with the tenants and remarket it and you become the landlord. Now you have the borrower comes and says, I'm struggling, I can't make my payments. Can you lower my interest rate? Can you defer some of my payments? This is called a workout. A workout is a concept where there's a default because the payments haven't been made, there's been a problem of some sort, but rather than just jump to the foreclosure where the bank swoops in and takes the property back, they make it a financial arrangement between them where there's some give and take between the borrower and the lender so that the borrower gets to keep the property.
Since they're not enforcing their right, do they forfeit them in a workout?
No, because every workout agreement will say specifically no, number one. Number two, every mortgage, lease, or similar contract will have non-waiver provisions in it.
So who are the people that would employ a workout professional? Like a workout.
What? Can you tell me what you're thinking of as a workout professional?
Like a distressed property needs someone to come in and kind of, like a lawyer, to come in and help rectify like what's going on.
Well, typically, what your problem is going to be, it's not going to be a legal problem.
No.
The purpose of the lawyer in that circumstance is more to negotiate the workout document between the bank and the borrower. To say, okay, you're going to give me X, the amount, and they're not usually that complicated. It's usually a reduction in payments. It's usually a provision of what happens to the arrearage, which is important. Because typically, you're not going to have the bank write it off. Because, by the way, if the bank writes it off, people that don't realize this, there's something called forgiveness of debt income. It's a tax issue. Where if someone says, oh, don't pay me.
Yeah. I've never heard of that.
Yeah.
Oh, this is like this. So this is the whammy that people didn't realize back in 2008. Ready for this? So the really bad situation where people, I don't know if I corrected the graph a little bit by the giant bubble at the top. So what was happening, I don't know if you saw me do that. So what was happening was in 2005, 2006, we had what was known as a bubble. And that's when you were seeing the 4-bedroom house in Pembroke Pines going for $650,000. And I'm just picking that because that was a real example because it should never have been that expensive. So people were buying the house for $650,000, and because of what was going on in the banks, they were financing $600 and putting $50 down. Okay, so a very high loan-to-value ratio, or as was discussed earlier as part of the commercial side, over-leveraging. basically just putting on too big a mortgage because they could, because of what was going on with the shenanigans with the
They weren't
financing.
holding the mortgages, they were selling them. They didn't have to worry about.
Right, well, the banks, but that's a whole other part of the crisis. But I want to stay on the borrower side, what happens. So now, when the curve went down again, that house dropped to $400,000, which is probably below what it is today, but that's what was closer to what the market was for that kind of a house in the market. I'm just using numbers, round numbers as examples. All of a sudden, here's somebody with a $400,000 house with a $600,000 mortgage on it. That's where the expression you may have heard being underwater. Okay, it didn't mean that they were living in Bikini Bottom. So, by the way, that was a horrible show on Broadway. Anyway, I was dragged. It was just stupid.
SpongeBob on Broadway?
Oh yeah,
Anyway.
it was really dumb. But that's another. That's after the camera goes off. I'll be happy to tell you.
We won't ask about.
It will not be on the test. So, I promise. The extra credit is, the extra credit question will be, who lives in a pineapple under the sea? And if you can't get that right, you fail. Okay, so, now you have the person is in the house. So a couple of different things were going on here. Now, this is the residential side, so the concepts are the same. So now the person throws their hands up in the air and they say, I'm not paying on a $600,000 mortgage when my house is worth $400,000. The words usually came out of people's mouths, I don't care about my credit. I put 50, what?
That was my question. So we know debt service coverage ratio, so who cares what it's selling for in the market? If you want to live there, you don't want to damage your credit. That's kind of my thought.
But because you're throwing good, the thought was, first of all,
You're throwing away.
you're throwing good money after bad.
You don't care. You don't want to.
Well, but you can live somewhere else a lot cheaper. That was the thought. Was they didn't care about the people didn't care about the credit. It was a mess. It was a royal mess. Okay. People walked away, so the bank foreclosed. The foreclosures were taking forever. Sometimes people lived there without making payments.
Right.
This is what was going on. It was so bad that people were staying 2 years and 3 years in a house, not making a mortgage payment, and the courts and the law firms and everything were so bollocksed up with this crisis that it was taking that long to do anything to get the foreclosure through. So they were just living there for free. All right? Wonderful situation for the people. So now finally it gets through the courts, it gets through the process. Oh, my house has been foreclosed. They're gone, they leave, they go, they find someplace else to live. It's done, it's behind them, they take a deep breath. And January of the following year comes along, and they get a little envelope in the mail from the bank, and it's a 1099. 1099 is a tax form when you receive money. And it is called forgiveness of debt income. And it probably was, I don't know what the exact amounts were, but it said that you owed us $600,000 plus another $50,000 of legal fees and foreclosure costs, so you owed us $650,000, and you gave us a $400,000 house, and therefore we forgave you $250,000 of debt. Okay, wait. That becomes taxable income to the person that's walked away from this house. Surprise!
But that's in lieu of an efficiency judgment?
No,
No?
that's another problem. Okay, stay tuned. So, technically though, you wouldn't, if they were able to enforce the deficiency judgment, you wouldn't get the forgiveness of debts because it wasn't forgiven. So, remember when we went back to the loan documents, it's like, we went back to the loan documents, okay? Remember the sleepy loan documents? Remember what I said were the most important words in the entire package of loan documents? Anybody remember?
Promise.
Who said it? I promise to pay, okay? That's on the promissory note. I promise to pay the $600,000 plus all the costs you incur if I don't pay you. So now we have a promise to pay that's up to $650,000. And they took the house back, And when they took the house back, the appraiser said the house is worth $400,000. So now, what happens to the $250,000? Deficiency judgment means that the bank can now go to the next step after the foreclosure and come and sue you. Well, they've already sued you, but they can seek from you, the borrower, the difference between what you owe and what the collateral is. So they can come and get a judgment against you. I'm sorry to say I did this for a little while because when real estate was in the crapper, I was helping do this. And I actually, the particular one that I remember was up in Port St. Lucie, which was one of the really bad places for foreclosures. It was a telephonic hearing because it was just the easy way to do it. And the judge said to me, "Your client loaned $150,000 on a vacant lot in Port St. Lucie?" Like incredulous because the lot was worth $50,000. "Judge, I'm just shuffling paper." "Yeah, okay, here you go." And he signed it. Now, did the bank ever collect? Probably not. If the bank wrote it off after they got that deficiency judgment, they may have tried to collect, but at the end of the day, if the bank forgave the debt, that's income to the person who didn't pay it. No, really, because if you think about this, it's forgiveness of debt. It's oh, stop. Go back to the hills. I told you, you get too hung up on the government stuff.
But they're taxing you on 1 year on the whole future balance of it.
No, they're taxing you in the year the debt was forgiven.
It's not realization.
It is realization. Before it happened, Ryan, before it happened, you owed $250. After it happened, you owed $0. You're up $250. I mean, that's the true economics. And the worst part of it, that I still never quite got my hands around, that bothered me a little bit is somebody's $250,000 just went poof.
No, it went somewhere.
Somebody's money went poof. Okay? I'm still not sure whose. I'm not sure where it came from. The bank got it from somewhere. The bank loaned it. It went into the house. They wrote it off. It went poof. There was the mark-to-market stuff where they were allowed to say that the asset wasn't worth what was, and they devalued and they took write-offs and tax money and bailouts from the government. But somewhere along the way, the money went away. It just didn't get paid, and it happened on a huge level. So, this is the mortgage foreclosure. This is the tax part of it, and it's real.
The other thing was the ARM loans, the residential adjustable rates. Whenever those, a lot of them had reappraisal requirements, right? And then when the market, this is back.
That's
home.
commercial. Not in residential, they never reappraisal. So on adjustable rate mortgage, I don't know if you've gone over that in the finance class, it's a floating rate, basically. It has caps, it goes up, goes down with the interest rates. People were taking them because when the rates were so low, they took the position that, oh, it's so low, I'm only going to pay 3%, and how much can it go up, and blah, 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 blah. Well, it really didn't go up. And actually, the rates went down in the crisis. I mean, it went down to like 0. But there was a time they went up big time, and that was a problem for people. But the residential ones didn't have reappraisals. What would happen?
What was the mechanism?
Well, for what?
Because we had a ton of them back home with ARMs that they just sunk. If it wasn't a reappraisal to adjust for the market value, what triggered the default?
People stopped paying. That's all it was.
Yeah.
There's no reappraisal in an ARM. I mean, you could theoretically have it. What he means is it would be a situation, and this would be, you find this in a commercial non-real estate loan or a margin account in securities, where there's a provision that says if the value of the collateral is reevaluated at some point in time, and it's determined that your loan-to-value ratio has exceeded a certain point, you're obligated to reduce the balance of the loan. You'll never find that in a residential mortgage, and probably not in a commercial mortgage either.
No.
It's either going to get called or not called. No. Very, very rare. And I've seen a lot of mortgage documents. It's,
reduce the balance like percentage, not overall dollar figure, because you just raise your equity. Like in like a margin call, you were talking in the stock
you don't necessarily have to decrease your leverage, you just have to increase your collateral.
Either way, you have a choice. You just have to get that ratio back into line. So in the downturn, I mean, the workouts. So everybody came for a modification. This is commercial or residential. Everybody would come for a modification. And when the foreclosure crisis was going on, what would happen would be, in the residential side, people would be, the judges would refer them to mediation. So you'd sit down, and this was a real flaw, because you'd go to the mediation, you'd have the bank's lawyer, and then you'd have the borrower's lawyer, and you'd be in the room, and of course the banker would be on the speakerphone because they were off in Calabasas, California, or somewhere in North Carolina, and they had no authority to do anything. Because you had whoever was assigned to today's phone calls at the bank was some mid-level vice president and had no real authority. So what they would do is they would offer to the borrower to take the arrearage, the unpaid payments, and maybe move them to the back of the loan. Figuring that, okay, if the market recovers, then at some point in time, they'll be able to pay some of it back, or all of it back, or they'll sell the house and they'll pay off the balance. That was one way it was handled. But invariably, every borrower said, oh, please make a modification, reduce my balance, write down my balance. It's only worth this. And of course the banks wouldn't do it, it was giving the money away. They might have very, very few situations where they might have actually done that, but think about it, you're asking the bank to give you a gift. As opposed to they're willing to help you, they're willing to keep you from losing your home, but they're not willing to, you took the money. You, the borrower, and I'm sorry, this is what happened, this was the bank side argument. You came to us, we're just the bank, you came to us and said, I want to buy that house. It's a great house, and I want you to loan me this money. And so we loaned you the money, we gave you the money. Why are you asking us to just write it off now? Because we're nice? I had one situation in a mediation where, and I will admit I took a little, no, I didn't take advantage. They were stupid. So it was my client had a refinancing transaction. So the people had refinanced it and now they were underwater. This is what was happening, is people that owned their homes, as the value of the home increased, as the appraised value increased, the lenders were willing to loan more money. So they would refinance it and take money out. Now they're in default. So now we're looking at the paperwork and we see there was a refinance and the loan balance was $120,000 and we see that they paid off a $60,000 mortgage 3 years ago. So the question was asked, what happened to the money? And the borrowers basically said, I put it in my pocket 3 years ago. So now they're asking for help? I mean, honestly, how much sympathy can you be willing to give somebody when they tell you right now they took the money? What did they do? They bought a new car, they did this, they took the money. But this is what happened in those situations. The other way to work things out that was helpful, and this is both the commercial and residential side, was what's called a short sale. I see nodding that people understand what a short sale was. And this was a situation where the banks made a business decision that they didn't want the real estate because that's not their business. They're in the business of dealing with money. Owning real estate involves obligations. You have to take care of it. You have to, pay utilities, and all kinds of taxes, all kinds of things. They don't want it. They want the money back. So the borrower would come to them and say, look, and the banks knew that the properties weren't worth as much as the mortgage. They knew they were underwater anyway, and they weren't going to get any more out of it. They would have to go through the process, and maybe they evaluated and saw that the borrower didn't have the money to go after, which is typically what would happen if they'd ask for financials. So they would negotiate a short sale. So back to my example, you had a $400,000 house, and you had a buyer for the $400,000 house. The bank might have said, okay, we'll take the $400,000, and then they might make a deal with the borrower, you pay us another $50, and we'll release you from the $200. Sometimes they were able to get that, sometimes they were able to get nothing. The problem came up when the borrower had a second mortgage. on the house. Because now the first bank is willing to take nothing. The second mortgage is going to get wiped out if there's a foreclosure, because there's no equity whatsoever. But in order to make the short sale happen, that second mortgage bank has to sign off releasing the mortgage from the property. Because if the title weren't cleared, you can't have a closing. And sometimes the second mortgage company would come back and say, just give us $10,000 and we'll go away. Something like that. And they may be owed 50, 60, 70,000, that they wanted a little piece of it too. And the big bank that had the big first mortgage would often authorize, it wasn't coming out of their pocket, well, it was technically, but, so they would take, instead of a $400,000 payoff, they take a $390 and make the deal happen. One of the things that I did, since I'm on this topic, I did notice the textbook mentioned specifically in their questions, it is not, I'm not putting it on the exam, but I want you to hear this, is that there was a prohibition that the lenders, in making these short sales happen, could not deny the real estate agents from their commission. Because it just wasn't fair, they were making the deals happen. But they actually did pass a law to that effect, that say, no, you can't, that's not happening.
The agreed upon commission.
Up to 6%, it was limited.
And the reason for that was because when that was happening, a lot of commissions were trying to get reduced in order to strike a deal. So agents kind of went into an uproar about that, because I remember that. I remember people not getting paid.
Well, I mean, commissions in big transactions are reduced all the time to make a deal happen, because if you don't have a deal, you don't have any commission. But I think the banks, somebody was pounding too hard and trying to take advantage. And honestly, to make the short sale happen, you have to have a buyer and a seller, and the only people that can do that are the agents. So that was part of the short sale process. I talked briefly about deeds in lieu of foreclosure, only because I was talking about delivery. That was one of the questions that we seem to have an issue on. If you remember, I used an example early on about people mailing the deed to the bank just to try and get out of the mortgage. And I said that deed is no good because it hasn't been accepted. So you have to have delivery and acceptance. What you don't have to have, and this is for whatever reason, it's like Family Feud and the #1 answer. For whatever happened, I don't know how this got miscommunicated. The grantee, the person receiving the deed, does not have to sign it. I don't know how that got there. Somebody, I guess in the conversation, it got confused, the difference between accepting it, meaning saying, yes, it's okay, versus having to sign off. The grantee never has to sign the deed.
So our old adage back home is signed, sealed, delivered, right? So we remember that, I mean, it doesn't have to be, it's the grantor, signed, sealed, delivered, right? The person receiving it, what constitutes acceptance? If there's no
Well,
signature?
if you take it and record it, if you take it, you take it.
But does it have to be recorded to be valid?
No, not as against the buyer and the seller. But in the real world, it's going to be recorded.
I know, but that's what I'm getting at.
In the 49 states, it is going to be recorded.
Right.
I can't speak to Arkansas.
But what constitutes acceptance?
If I hand it to you, and we're sitting across the table, and you take it from me, and you don't say, no, I'm not taking the deed, but if you take it from me, that's acceptance.
Who witnesses it?
Is there a
Who
statute?
witnesses what? The deed?
Or acceptance?
Well, I don't think
There's no signature validating that they accepted it.
That's what I'm getting at.
Well, because the next step in every jurisdiction, the next step with the deed is you send it to be recorded. Because that's how you prove that you own it.
Both parties have to go to record it?
No. No, but so what happens is it goes to a title company,
Uh-huh.
okay, like an escrow agent or a lawyer. We have a closing. The grantor signs it, the grantor delivers it, the grantor gets the money, the seller gets the money, and we send it off to the courthouse for recording. And that's just normal practice. That's perfect evidence of delivery. Because non-delivery would mean the buyer doesn't have it. If the buyer didn't accept it, what's the buyer going to do? Obviously, if the buyer's moved into the property or taken occupancy or something, they've accepted the deed. You can't, in the situation I'm talking about with the lenders, so a deed in lieu of foreclosure is a situation where instead of going through the judicial process, if there's no intervening liens, so it's got clean title, instead of going through the 6 or 8 month process, they make a deal, and often the deal is related to not chasing you for the deficiency judgment. where the borrower will actually give a deed to the property to the lender. That's a deed in lieu of foreclosure. However, it's a deal that's made, an agreement is made for delivery and acceptance, and then the lender issues a release of the debt. What was going on, the abuse that was going on that I was talking about was the borrowers, the underwater borrowers, were signing a deed, properly witnessed, proper deed, and mailing it to the bank. Just like that, saying, I'm not paying anymore, here. Well, that's not valid. Now, if the bank said, okay, and took it and sent it to be recorded, that would be valid, because that would be accepted. But what really happened was the bank would write a letter and send it back and saying, no, you can't do this.
Well, they couldn't transfer it because of the mortgage lien on it, right? That would invalidate it, wouldn't it?
Invalidate what?
The transfer of the deed.
To the bank?
I mean, yeah.
Well, you have a merger.
I follow.
Then you'd have a merger. Then you'd have the bank holding the fee simple and the lien would go away.
Okay.
So the buyer or the receiver of the property records the document, right?
Yes.
Okay, so that's acceptable.
And the purpose of the recording is as against subsequent people out there without notice. That's the Recording Act stuff.
Is there any statutory minimum for a recording of a deed?
$10.
No, I mean like a time period.
No.
So, okay, so then
No.
it's not invalid, it's just not.
Stupid.
Yeah.
It's stupid because
I
somebody
follow.
else could run and get an intervening interest.
Okay.
Okay? So that's what a deed in lieu of foreclosure does. Questions? Zombies? All right. I feel the vibe. It's okay. I don't mind it. Kill the machine.